Hey, Clerk, I'm just checking if you can hear me okay.
Yes, can hear you fine, Chair. That's us live now, so ready to go.
Okay, thank you. So I now declare the meeting open to the public online, and I'd like to welcome all of our members who are participating by video conferencing. I would also like to remind members about the protocols regarding the use of electronic devices. So, members, in terms of apologies, we do have an apology. Carol Nicullen will need to leave the meeting early today and has assigned her vote to either myself or Orlia Flynn, should that be necessary. And myself in the first instance, but and Orlia if I wasn't here. But so is any members aware of any other apologies? Or Clerk, do you have any apologies? No. Okay,
No,
thank
Chair.
you. Thank you. So, moving on then to draft minutes. I refer members to the draft minutes of the meeting of the 2nd of December at tab 3.1. Are members content with those minutes? Yeah, content. Thank you, members. And members are. I also refer you to the minutes of the meeting of the 7th of December on Tuesday of this week, which are included at tab 3.2 of the table papers. Are members content with those minutes? Yeah, thank you, members. So there's no matters arising, members, so we can move immediately on to our first substantive briefing session today, which is on the Adoption and Children Bill. We are today taking stakeholder evidence from the NSPCC and the Commissioner for Children and Young People. So, members, you will be aware this is the second evidence session on the Adoption and Children Bill. Unfortunately, the Human Rights Commission were unable to attend today's session, but they will be rescheduled for next week. I would like to refer members to papers at tab 5 of your pack, which include submissions from the NSPCC at tab 5.1 and from NICCY at tab 5.3. And I would now like to welcome by Starleaf Miss Natalie Wheelahan, who is Public Policy and Public Affairs Manager with the NSPCC. And I'll just check, can you hear our sound okay, Natalie?
I can, thank you, Chair.
Thank you very much. And we're also joined once again by Kula Yusuma, who is the Commissioner for Children and Young People here in the North. Good morning, Kula. Can you hear us okay?
Yes, thank you, Chair. I can.
So hearing you fine there, Kula. So listen, I want to thank you both for your submissions to committee. I want to thank you for assisting us in terms of our scrutiny of this bill. And I will go just in order that I have you on my list here. I'll go back to Natalie for opening remarks, and then I'll come to yourself, Kula, and then we'll go to members' questions, if that's okay with everyone. So Natalie, go ahead, please.
Thanks very much, Chair, and thanks a million for inviting us to give evidence to the committee today. We're really grateful for the opportunity to give evidence on the Adoption and Children Bill, and we hope that our input will be useful in your consideration of the bill. We very much welcome the introduction of this bill, which delivers on the Department of Health's long-standing commitment to reforming adoption law in Northern Ireland. The bill also makes a number of welcome amendments to the Children Northern Ireland Order 1995, and we're pleased that the Department has taken this opportunity to make amendments to improve outcomes for looked after children and young people and for those who have left care. The bill is extremely complex, and a great deal of the detail as to how aspects of it will operate in practice has been left to a number of regulations and rules of court to be developed after the bill is made law. It's therefore difficult to provide informed comment on the bill and its outworkings at this stage, but ongoing engagement with key stakeholders will be very important in progressing this work. There are many areas of the bill that we welcome, and we've highlighted these in our written evidence. We don't have comments to make on all of the clauses of the bill, but rather we wish to comment on a limited number of discrete areas which NSPCC believes warrant further consideration. As we approach the end of the Assembly mandate, it's crucial that these vital and overdue legislative reforms are progressed without delay. So firstly, I want to come to Clause 133, which amends the definition of harm in Article 2 of the Children Order to take account of the impact of domestic violence on children. It amends the current definition to include impairment suffered from seeing or hearing the ill treatment of another. The requirement for a child to have seen or heard the ill treatment of another to come within the definition of harm under the Children Order does not reflect the approach taken regarding the child aggravator in Article 9 of the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021. In recognition of the damaging impact on a child of living in a home where domestic abuse is taking place, there's no requirement for a child to have awareness or understanding of the abuse for the child aggravator to apply. The impact of abuse on children is profound, and the risk of harm to children is not dependent upon their awareness or understanding of the abuse. As outlined in our written evidence, children who experience domestic abuse are at an increased risk of physical, psychological and emotional harm and neglect. They can also be detrimentally impacted upon by their parents' compromised capacity for parenting. This impacts on all children, including very young children, and threatens the attachment relationship with their parents. It's vitally important that the definition of harm in the Children Order takes cognizance of the corrosive impact of children of living in a home where domestic violence is occurring, whether the child has an understanding or awareness of the abuse or not. NSPCC recommends that the definition of harm in the Children Order be amended to reflect that a child can be severely adversely impacted upon by domestic abuse in the home, even if they don't see or hear the abuse taking place. In light of the statutory recognition of harm caused by living in a home where domestic abuse is taking place in the Children Order, we would suggest that this places clear corresponding obligations on the government to respond to this harm to aid the recovery of children who are harmed in this way. Children who have experienced domestic abuse should have a right to access consistent, high quality and evidence-based therapeutic services to help them recover from the trauma of this experience. Sufficient emphasis on recovery and support remains lacking for children who are victims of domestic abuse and their families, and we would like to see the introduction of a statutory duty on health trusts to provide specialist domestic abuse support for children in the bill. NSPCC knows that with the right support, children affected by domestic abuse can go on to recover and enjoy happy and healthy childhoods. Evidence has identified that children have a better chance of recovering from domestic abuse when they have a strong relationship with the parent victim of abuse, usually the mother. NSPCC's Domestic Abuse Recovering Together service helps children and mothers to talk to each other about domestic abuse, learn to communicate and rebuild their relationship. Evaluations of the NSPCC DART programme found that mothers' self-esteem and confidence in parenting increased, and they reported more affection towards their children, and children had fewer emotional and behavioural difficulties, and reductions were greater among children who had received DART than those involved in an alternative service. The provision of sufficient and specialist support services for children will be key to ensuring that the harm caused by domestic abuse is minimised. A statutory duty on health trusts to provide specialist support and recovery services for children affected by domestic abuse and their families would go some way to ensuring that the harm caused by domestic abuse does not define children's futures and that they can recover and go on to lead happy and healthy lives. Clause 199 introduces special guardianship orders. These were introduced in England and Wales in 2005, and it's welcome that the proposed provisions take into account some of the learning from how they've operated there to date. However, one of the failings identified with the operation of special guardianship orders in England and Wales has been the lack of adequate preparation and support for special guardians. We would therefore like to see special guardianship support on the same basis and with the same eligibility as adoption support in Clause 5 of the bill. In light of the well-recognised need for improvements in the educational outcomes of looked after children and the need for greater permanence and stability in their lives, we welcome Clause 122, which introduces a duty on authorities to provide and promote educational achievement and prevent the disruption of education and training. We would be keen to know the extent of this duty and the specific requirements which authorities will be under to ensure compliance. In specifying these requirements, it will be important to interrogate the underlying reasons why disruption to placements and therefore education and training continue to occur and address their root causes, as this is a symptom of wider failings within the care system. Clause 123 introduces a framework of corporate parenting principles for health and social care trusts. These are high-level principles, and it would be useful to know what specific obligations will result on the trusts as a result of these principles, as well as any potential consequences where a trust does not act in accordance with these principles. With regard to the principle helping them gain access to services provided by the trust and any relevant partner, we would suggest the inclusion of access to suitable and appropriate services which will meet the needs of the child. We would also refer to the Children and Young People Scotland Act 2014, which introduces a range of duties and responsibilities on corporate parents, which might be of assistance in determining how compliance with these principles could be determined. Clause 1211 introduces a power for health and social care trusts to provide accommodation to a disabled child for the purposes of providing short-term breaks outside of the looked after children system. We recommend that consideration is given to defining further other categories of children to which this provision could relate. There are a number of groups of children, and some of whom I've mentioned in our written evidence, for whom such provision would be beneficial, and it will be important to engage with stakeholders in the development of regulations relating to other categories of children to ensure that all groups of children who require this support are included in order to be able to access it. Finally, Clause 132 introduces statutory advocacy services for looked after children, former looked after children, special guardianship children or adopted children where they're making representations in the context of complaints or reviews. This is extremely welcome, but we would seek assurances that advocates will be independent of the statutory sector and regulated. Advocacy should be available to children of all ages to facilitate them to have their voices heard and taken into account in decisions about their lives in line with Article 12 of the UNCRC. We would like to see advocacy services being configured under the bill to allow young people to appoint an independent advocate of their choosing, particularly where they've worked with a particular advocacy service, or where they have a good relationship with an advocate, or where they feel that a specific service is best suited to meet their needs. A key aspect to advocacy is the right to express views and be heard. We would therefore like to see the extension of the provision of advocacy services to situations outside of the limited context proposed in the bill, to assist children and young people in ensuring that their wishes and feelings are heard in all matters concerning them. This is particularly important given the complexity of the care system, the particular vulnerabilities of children in, entering or leaving that system, and the emphasis in this bill on capturing the views and feelings of children and giving them due regard. NSPCC would like to see all assistance being given to children of all ages to help them express their views and feelings at every stage of their journey through the care system. Thank you.
Thank you very much, Natalie. And I'll go straight across then to yourself, Kula, if you want to go ahead, please.
Thank you very much, Chair. And we are running the risk of you hearing very similar evidence, but that's the nature of the thing. And I will try to, as I speak, to take out bits that Natalie's already said. But as you would, like I said, anticipate, I agree with almost everything she said. So again, I too would like to thank the committee for the opportunity to give evidence today and welcome your commitment to ensuring that this bill provides the highest standard of care and protection for children and young people. I am mindful of the breadth and depth of the bill and acknowledge the considerable work that's already been undertaken by members, by the Minister and departmental officials to seek to secure this legislation within what is now a very limited window of this mandate. I also want to thank departmental officials for their continual engagement with my office at all stages of this bill's development. As you are aware, the legislation which established my office lays out our statutory duty, which is to safeguard and promote the rights and best interests of children and young people. So my evidence today is not intended to be comprehensive across all clauses of the bill, and like I said, try not to repeat what you already heard from Natalie. But to look at key aspects, some of which were already highlighted in our written submission. But before commenting on these, I would like to note the children's rights obligations that are placed upon our government, statutory agencies, and indeed this Assembly in this area. The United Nations Convention on the Rights of the Child sets out minimum standards for children's rights across all areas of their lives. And the four guiding principles which flow through the Convention are children's rights to non-discrimination, their right to survival and development to the highest level, their right to have their best interest as the primary consideration, and the right to have their voice heard in all matters affecting them. And of course, through every you'll see particularly these four principles in every aspect of this bill. And Natalie talked at length about the advocacy, the importance of advocacy, and as outlined in Article 12. Moving on to specific clauses of the bill. Clause 116 addresses the definition of family proceedings, and NICCY warmly welcomes the proposal to ensure that female genital mutilation protection orders are included in the list of family proceedings for the purposes of the Children Order, which will ensure that all relevant proceedings for the protection and welfare of a child can be made. All relevant orders can be made within proceedings, Clause 119, and Natalie's already talked about special guardians, has the potential to give clarity and stability in the lives of children and young people whose care and living arrangements are not covered by other mechanisms. But as you've already heard, it's crucial that support services, including financial help, is available for carers and children and young people to properly meet their ongoing needs after a special guardian order has been made. Otherwise, having this status could create a disadvantage for those it is intended to help. In clause 121, NICCY would like to see the practical implementation of this clause to also result in stronger partnerships between the statutory and voluntary sector to provide the services and supports that children need. So that clause 121 is a really helpful clause, but actually it should be extended to ensure that the statutory agencies can bring in partners to ensure the delivery of services. In clause 122, and again, we've already, Natalie's already spoken about this, but it's worth repeating. So whilst NICCY welcomes the creation of a duty upon authorities to prioritise educational achievement for children and young people, its use of the word promote is insufficient. The word promote is not strong enough to indicate to us how this duty will be implemented or even achieved. It's important to compare what happens with parents and other people and individuals who have responsibility for children. The Education and Libraries Order 86 places a duty on parents in respect to education. Failure to discharge this duty can result in parents being issued with a school attendance order, a supervision order, or other judicial action. But at present, there is a lack of clarity as to how the corporate parent can be held to that same standard. Surely children who are in the care of the state deserve the same standard and the same rights to education as other children. So this clause needs to be strengthened to do just that, to provide a duty on the corporate parent to ensure the child receives an efficient education. Moving on to clause 123. Again, we welcome this clause, but again, we will need to see more detail in regulations that will outline how corporate parents will provide evidence that they have applied the 7 principles outlined in the clause and how they will be held to account for that. Otherwise, this clause is just a warm, fuzzy feeling for everybody, but doesn't necessarily deliver tangible benefits for children and young people. In clause 120, and I'm not averse to warm, fuzzy feelings, but not in legislation. Clause 125. The need for minimum standards in respect of accommodation for children and young people is imperative. While NICCY welcomes the intent in this clause, we recommend a revision to the draft of paragraph 7a. From the department may, by regulations, impose requirements to the department shall, by regulations, impose requirements. We make this recommendation with a view to ensuring that the whole child is taken into account when providing an alternative accommodation for them. My comments about the previous clause about impact stand for this one too. Clause 129. You'll be pleased, Chair, I'm getting there. Proposals to ensure that care leavers are made aware of services available to them is really welcome in clause 129. But again, for this to be effective, there should be a statutory timeframe in which those young people are directly advised of the services available to them sufficiently in advance of leaving care so they can plan and effectively avail of such services. As such, a time frame should be included in the regulations. And then we move to clause 133, and Natalie has spoken at length about why we need to be broader around the definition of harm. And I'm just going to say a few things that will support what she said because it's worth repeating, as I say. So again, I warmly welcome the interest of members in ensuring that this clause provides proper protection for children and young people affected by domestic violence and abuse. And as highlighted in our written submission, and as Natalie's already said, the proposal to amend the definition of harm as set out in the Children Order was discussed with your colleagues on the Justice Committee during their scrutiny of the Domestic Abuse and Civil Proceedings Act. And members may be aware that the Justice Committee gave detailed consideration to ensuring that harm that can be caused to children affected by domestic abuse is effectively captured by their Act. Following on from this, I welcome the intention of the Department of Health to ensure that definition of harm within the Children Order will also reflect that children can be deeply affected and harmed by the ill treatment of another, including but not only in relation to domestic abuse. And we also welcome the intention to ensure that such harm can be considered in relevant proceedings concerning the child, including contact and residence orders. But I repeat the call you've already heard, and I make a strong call that this provision should not include a condition which requires a child to have directly witnessed or have heard incidents of abuse. Natalie's already said why that is important, and again, like I said, I'm not going to repeat it. Following discussions with the department, we understand that they are actively seeking to ensure that the clause B can be amended to capture the harm to children without such a condition, and that the amendment may reflect the definition provided for in the Domestic Abuse and Civil Proceedings Act. Children do not have to be a direct witness to the harm to be adversely affected by it. We welcome the intention to further explore this and ask that the committee seek further clarification for the department. So in conclusion, I again wish to acknowledge the committee's commitment to fully scrutinising this really important legislation, and will welcome any comments and questions from members on this and any other clause, although I can give no guarantee that I'll be able to answer them efficiently. Thanks.
Okay, thank you both, and we don't doubt your ability to do so, Carla. But by all means, if there is anything that you want to elaborate on or expand upon, maybe in writing following the session, we would also appreciate that. And maybe in some issues, just in an interest of time, that's a good approach. Yeah. So whichever works in that regard. So listen, a couple from myself first. First of all, and I note you both touched upon the issue. I think it's clause 122. Around the duty or what is currently promote educational achievement. So I'd like to ask both of you how you may do that, how you would do that better, and what practical steps could be taken to promote what type of thing, in your experience, would achieve that. And before I get the answer, actually, it's a good opportunity maybe for me to express my interest as having been a social worker previously, and just to put that on the record for the meeting. So I'll go to yourself, Carla, and then back to Natalie in relation to the the duty and the ability to better promote educational achievement.
You see, I don't like the word promote, as I've said, Chair. I don't like the word promote. I think the word promote is too woolly. You know, we can all promote. So promote is an encouraging word. We can all encourage children to go to get up to school. We can all encourage services to be available. But with parents, if their child, if my children when they were school age didn't go to school and I didn't do enough to ensure that they did go to school, I would be held legally accountable for that. So I suppose what I would say is if we place the same duty on trusts as we do on parents, then what we would then have to do is ensure particularly foster carers and residential care workers had all the necessary training and skills to be able to get their children in their care into school, that those children receive the proper therapeutic interventions to be able to deal with their trauma, whatever trauma they had experienced, and it's likely that they've experienced multiple trauma, to be able to get into school, because we know if a child's got other issues going on, they're not able to engage in education effectively. But if they receive the services to be able to do them, and also to support schools to take into account what those children are experiencing. So we would want to see personal educational plans completed, the plans in which the young person was involved in. But ultimately, the excuse, I couldn't get him out of bed this morning, it's not good enough for parents and it's not good enough for trust. But we know that we need to support our workers on the ground to be able to discharge that duty. A lot of work's happened in the last 20 years, some of which I have been involved in. But we need to up that to ensure that the educational experience of our looked after children, or of our children who are cared for, improves dramatically.
Okay, thank you. And I do actually indeed note the fact that there are several concrete suggestions there, and I think that's very useful and very interesting for the committee. Natalie, I'll ask you the same question. I'll go over the question again because I'm conscious you've dropped in and out a little there. So I was just asking around the duty, the issue of educational achievement. So in relation to that, what practical steps could be taken to improve educational achievement? And I do note your proposal or your evidence that should be strengthened, and I think that's a very useful addition to the evidence. But can you outline for us what you think practically could be done to promote that, or to deliver on that need for a better educational achievement?
Yes, apologies, Chair. I seem to be having some connection difficulties, so if I cut out again, I'll just try and get back in again. So, in terms of educational achievement, we know that the outcomes for looked after children in education aren't as good as we would like to see. There's a range of reasons for that. And we know that there needs to be an emphasis around meeting the needs of the individual children. I do think that what is being proposed in terms of some of the proposals in the bill around extending support for looked after children up to the age of 25, if they're in education and training, will really help with that, because often looked after children have had really kind of disrupted education as a result of the things that have happened to them in their lives. And so it is important that this is seen as something that is supported right throughout their lives. There is also a need. I'm aware that the Fostering Network made some suggestions. I had a look at their written evidence to the committee, and they had made some suggestions from a consultation that they had carried out, which I thought were really good, in terms of looking specifically at support around special educational needs, but getting to know the young people that we're talking about here, the difficulties that they face, and trying to meet those individual needs. It won't be a one-size-fits-all when you're talking about these sorts of children and the traumatic experiences that many of them will have faced. So it is, as Kula has said, about personal learning plans where young people are involved in the development of those, but making sure that what is proposed and the targets set for each individual child takes into account their individual needs and realistic targets that they can meet, that doesn't necessarily conform to the education system that we I suppose have in place for all other groups of children and young people. We do have to be much more creative around how we meet the needs of these young people, and that will involve additional services for children to meet their individual needs with their involvement that continues beyond what we consider to be the lifetime of their education career, really.
Yeah, thank you. And I also did note from both of you the need to include children in this conversation, and we will indeed be ourselves meeting with care leavers in relation to our scrutiny of the bill and fostering network. So I may come back with an additional question on that, but I do want to get the members. So for now, I'll just conclude around the question around clause 133 around the domestic abuse. The committee have raised it. There have been concerns raised previously, and I don't think we are overly surprised to hear that you concur with that concern. I mean, I as a social worker, you were hugely aware of the whole toxic trio and the impact that had on so many people. But even outside of a professional basis, we all know where we walk into a situation where something has clearly happened, and to use the phrase, you could cut the atmosphere with a knife, and how uncomfortable and distressing. So clearly, you don't even have to be inside a house or with people to pick up on that. And the repeated picking up of it, we now much better understand around the whole plasticity of developing brains and all of that, and that repeated trauma, repeated adrenaline surges, and the impact that has on people. So I think that is something that we will, I think, maybe write to the department on to see if they're potentially looking at, because I think that's been raised by many members, and it seems a very obvious thing. So in relation to how that could be improved then, what would your own ideas be in relation to potential amendments around that? I'll go to Natalie first, and then I'll come to yourself, Carla.
Thank you, Chair. Well, we would like to see the definition reflecting the definition that is taken forward in the child aggravator clause. So we don't want to see an obligation for a child to have seen or have heard domestic abuse in order for it to be considered harmful to children. As I've said in our written evidence, the psychological impact of living with the day-to-day reality of abuse, and you've talked about that as well, has a really significant detrimental impact on a child's sense of self, safety and well-being. Studies that we have looked at estimate that children living in a household with domestic abuse are 3 times more likely to have a conduct disorder. Children living in a household where domestic abuse has taken place are detrimentally impacted upon by parents' compromised capacity for parenting. And it does impact on very young children. And I think that's the important thing as well, that the attachment relationship with their parents can be threatened by domestic abuse. And the requirement for children to be aware of the abuse taking place completely undermines the impact of that abuse on very young children. And so I suppose one thing we would like to see is a reflection of the definition in the Children Order that takes account of the Domestic Abuse and Family Proceedings Bill. So we'd like to see those two marrying up so that there's no obligation on children to have any awareness of the abuse taking place. But as I said in our oral evidence, Chair, is that we would also like to see a corresponding obligation on government to respond to that harm. Because at the minute, services are very piecemeal for children. There's a tapestry of services which are dependent upon funding relationships within the various trust areas. Varied support for children in relation to their experience of domestic abuse, a lack of central support, piecemeal funding, and real lack of clarity around the evidence base about the services that are being provided. So if we're serious about the impact and the harm of domestic abuse on children and young people, including very young children and young people, we do need to see a response by government to meet those needs and to aid their recovery. And I suppose that's one of the things that we feel has been lacking. And we did talk about it under the domestic abuse legislation as it went through the Assembly. And it wasn't possible to bring an amendment forward through that piece of legislation. But it is something that we would like to see a much greater emphasis on in terms of the support for children, given now that we will have the statutory recognition of the harm that they suffer under the Children Order.
Okay, thank you. Carla, do you want to add anything to that?
Yeah, just very, very quickly, because Natalie's given you a really comprehensive response. I think that by having this narrow definition of having seen or heard, I think that binds the hands of social services and other agencies whose job it is to protect. Because what we want is, if a child is living in that situation, including babies who cannot actually articulate whether they've seen or heard anything, and as Natalie says, we don't always want them to. What you want is there to be an assessment of how they have experienced that harm. You don't want to have the conversation, tell me what you saw, and then I'll assess whether you were harmed. Tell me what you saw or heard, and then I'll assess whether you were harmed or not. And if you didn't see or hear anything, then I can't make that assessment. That is not helpful to those who are charged with understanding the impact that particularly the adverse impact that's had on children and young people. So it is right that if there is a family where there is such harm, that there is an automatic assessment and understanding of how that harm has impacted on the child, and that we shouldn't have a narrow definition of whether they witnessed that harm. But then also, as Natalie has said, an automatic triggering of particular services that will be able to address whatever trauma or experience that that child has had and how they need to get over it. So I actually think the way it's currently defined is not helpful to people who are trying to assess that impact, because you have to, first thing you have to ask is, tell us what you saw, tell us what you heard, rather than how are you, what's going on, how are you feeling. And that's really the conversations. I should declare I'm also an ex-social worker, but I've taken the pill. I'm fine now. But that's the conversations we should be having, not like I said, a straightforward, what did you see and hear? So that's just to support what Natalie has said.
Thanks, Carla. I'm glad you're fine now. I'm still in recovery, but I'll get there. Okay, so I'm going down to members. So I have members in this order at this point in time. I'm going first of all to our Deputy Chair, Pam Cameron, then Paula Bradshaw, Colin McGrath, Carol Killen and Arlea Flynn. So Pam, go ahead, please.
Thanks, Chair, and good morning. Natalie and Kula, I really appreciate your attendance at committee and the evidence you've given so far. And I apologise, Natalie, I've been kicked out 2 or 3 times already. So if you've already gone over this, and you can tell me to shut up and I can read it in Hansard. But appreciate the Chair's already gone down the route of talking about the requirements and trust to promote educational achievement and to fulfil that role of corporate parent. And appreciate some of your commentary around that. But do you know what useful arrangements are in place in other jurisdictions? That'd be my first question. And what do you think would be an appropriate penalty for trusts being to act contrary to these duties?
Who's going to go first? Natalie, okay, I'll jump in first. I think that's the crux. How do you hold a corporate entity to account for something? Because what are you going to do? Are you going to place a supervision order on the chief executive or the chair or the minister? We don't want to get into ridiculous scenarios. But what we do need is something that does hold them to that standard. How we do that, I don't know. Are we talking judicial reviews? Are we talking, I don't know, fining them? And I don't want to see less money going out of the system. Are we talking putting them in special measures? I'm not sure, to be honest, Pam. But what I do know is that these children need to have the same standard of expectation that they will achieve and in education as other children will. With regards to, I haven't looked for a while, and Natalie, working for a national organisation, may know a little bit more than me. I haven't looked for a while what's going on across the water, but some of the other things, following on from the answer to the chair, we've seen in fostering where foster carers have been given a sum of money or support to support the children in their care, their education. That's often include digital devices and access and things like that. We need to see something similar happening in the residential care space. So we need to ensure that children and young people have access to space to do their homework, have access to the digital devices to do their homework. As I say, have access to all the supports necessary, and staff are able to do that. The other thing that I did when I was working on this, was aware across the water, was that they had a virtual head principal in council areas, whose job it was almost to have an overview of the achievement of the children who were being looked after in his or her council area. Now, how that's developed, I'm not sure. But again, it's about, are we carefully monitoring how our children are achieving? Are we taking into account, as Natalie says, the trauma? So is it reasonable to expect them to achieve 5 GCSEs, to have that same standard of 5 GCSEs at age 16, bearing in mind the enormous trauma and disruption? Should we extend that as appropriate for some children? Not for all. Others will be flying, and education is their safe place and it's where they fly. But for some children, we should allow that they will need mandatory education up till 21, 22, 20, and maybe as high as 25, because of the trauma they've been through. So we need to take each child, as Natalie says, using the personal learning plan and saying, what will work for you, and how can we do this? Is it practical? Is it therapeutic? Is it that you just need somebody to stand by you every morning to make sure you get out of bed? And every parent has had that experience. So it is about this notion of a trust, behaving as any reasonable parent would. What would that actually mean? And we've talked about that in the principles of corporate parenting. And this is what we're talking about, the very practical way of making sure that children in their care receive a good education. So that was very long-winded and not much concrete, but that's where we're at with that.
Just coming in on that, Pam. We have had some conversations with our colleagues who work in various jurisdictions across the UK, but and there are lots of initiatives happening at local authority level, some of which are successful, some of which not really. I suppose the crux of the matter really is that it's treating that individual child in their own right, looking at the needs of each individual child and responding to those needs. The difficulty with that, Pam, is that it tends to be a bit more resource intensive. And so, it is that sort of having that adult that they know that they can rely on and come to, and who will be the one, as Kuda says, is there to get them out of bed in the morning if that's the issue, or and those kinds of initiatives which look at the whole child, meeting the needs of that child. I mean, how do you expect a child who is suffering trauma to achieve an education if you don't address that trauma first, and changing those targets for young people who are looked after in recognition of the fact that they may have suffered trauma, that there has been disruption in their lives, and that, and trying to respond to each individual need, allowing that journey to continue for a longer period of time, looking at the challenges that each individual child faces. For example, if there are special educational needs or additional needs of any kind, ensuring that those needs are met. nurture rooms are one thing that works particularly well for children who may have suffered attachment issues as a result of disrupted parenting. There are a range of initiatives that work well for looked after children. There won't be a one size fits all, but it is very much about the child being at the centre of the response. I could certainly go and talk to my colleagues again in England and Wales and come back to the committee with additional information if that's something, Pam, you're particularly interested in, because if there are initiatives that across sort of the various nations that you may want to have a look at, I can come back to you on that one. I do know that there are some, but the ones that are most successful are the ones that put the child at the centre and try to meet the child's needs and meet them where they are. And as Cuala says, those targets of 5 GCSEs won't always work for looked after children, and we know that. But it's about ensuring that the system is flexible enough to respond to the needs of the child.
Great, thank you, Natalie. And I would appreciate that if you could gather any information and send it forward to us. I think that would be very useful. Chair, could I ask another question?
Yeah, go ahead, Pam.
I wanted to ask whether you believe the bill writes the department, and by extension the trusts, a blank cheque, as it were, in terms of delegated powers, and which specific arrangements do you feel should be being stipulated in the bill which are currently reserved?
Pam, you've I'm not sure I know how to answer that question. I don't see that the bill writes anyone a blank cheque. But what specific powers are you thinking? I'm trying to look at Natalie here to see if you're any the wiser. But I didn't see anything in this that thought it gives them a Bible or on anything. What I do think is it's not strong enough, and I think regulations in a number of areas will need to be tightened. Like I said, I think some of the clauses are a little bit woolly, but I think that relationship with the department and the trusts and other relevant authorities in discharging some of the duties in this, including education, definitely need to be strengthened. I just want to quickly go back to education. There's some really good work happening in Northern Ireland around the education of looked after children, particularly in Belfast Trust, where there is in the Belfast area where there is a formidable advocate employed by the Education Authority, Anne-Marie Bagnall, on this stuff. So I think it would warrant the committee to hear from her, even in written. So sorry, but going back to your reserve question, I'm not sure I understand the question, Pam, and that's me showing my ignorance. That's okay. Maybe not, Natalie.
Could you repeat it again for me, Pam? I couldn't hear you.
No problem.
Oh God, it's not just me.
So what I was asking was whether you believe, and you did really answer the first part of that, because you don't believe that the department has been is writing a blank cheque by extension trust, in terms of the delegated powers, and the second part of that was which specific arrangements do you feel should be being stipulated by the bill that are currently reserved? But if you don't believe the first part of it, then you don't.
Sorry, Natalie, but I think how the department holds the trust to account is critical in all this, and that's why I mean about tightening up. But I don't see that it's a disproportionate relationship, I think. But Natalie, you may know more. Natalie's cleverer than me on these things.
I don't really, but I suppose I don't really see it that way, Pam. Right. To be honest with you, I see a real opportunity in this bill for there to be much greater pooling of resources, actually. And so when it comes to the department's responsibility for certain functions and those transferring to trusts, and you talk about a blank cheque, I don't really see it that way. I think that, I'm aware that some of the things that we are asking for as NSPCC, for example, the statutory duty on health trusts to provide support services, specialist support services, if they have been harmed by domestic abuse, for example. I know that there are resources that flow with that. And the answer I would give if I was asked about that is I think that we need to be much more creative as a government and look at the Children's Services Cooperation Act and how we pool resources and how we meet the needs of children. I mean, it remains to be seen if the transfer of functions from the department to the trust will be more effective in meeting the needs of children. I think But if the department feels that there's a good rationale for that and they have a good reason for that, then that's fair enough for me, as long as the resources go to the children that need it, and the children that need it get the services that they need when they need it, and those services are fit for purpose. I don't have an issue with that. If it puts trusts or the department under pressure in terms of what we feel is required, and I mean, it goes back to your point around educational attainment, what will work there. Some of the things that will work there for children, particularly the most traumatised children, will require funding. And if it's not something that the Department of Health has the budget for, or the individual trusts has the budget for, there is an obligation on the other government departments to come together to pool the resources to meet the needs of these children, particularly when you're talking about education, because some of the responsibility will rest with the Department of Education there. So it's not the structures that we would really have an issue with. It's more to ensure that the structures facilitate meeting the needs, the assessed needs of those individual children, and they get the help that they need when they need it, really.
Lovely, thank you.
Okay, thank you. Thank you. And I'm going into Paula. Go ahead, Paula, please.
Good morning. Thank you, Chair, and thank you, ladies, for coming to committee this morning. Apologies for the delay. The sound was off. My first question relates to a comment you made, Natalie, there around it's difficult to inform given that some of the provisions will actually have to go into the regulations. And so I'd like you to speak a wee bit to that, and also any concerns you have that the draft foster care regulations are still not through. So that's just the first question. Thank you.
Thank you, Paula. I suppose whenever I was doing my written evidence on this, I was conscious that I wanted to try and be as comprehensive in our response to the committee as possible. And as I was going through it, I kept being a bit frustrated because I was seeing references to regulation that key stakeholders and children themselves are involved in the development of and the process of this legislation as it moves forward. The other question that you asked there, Paula, was in relation to the fostering regulations. We know that these were consulted on in 2014, and it is something that we raised in our written evidence, that we would like to see these moving forward. And the reason, I suppose, for the urgency for this is we have seen a real increase in the numbers of looked after children in Northern Ireland. So I think since the introduction of the Children Act, there's been a 30% increase in the number of looked after children in Northern Ireland, and a 6% increase since September 2019. So over the course of the pandemic, we've seen a 6% increase again in the numbers. So at the minute, I think the most up-to-date figures we have from this week, there's 3,500 approximately looked after children in Northern Ireland at the minute, and that's very high. We need to be doing everything we can to improve the lives of looked after children, including legal reform. And this should include the expedient introduction of the draft foster care regulations to develop standards for foster care, which are complementary to the Adoption and Children Bill. And we see this as a really key opportunity given the development of this bill. So as I said to you, these were consulted in 2014. They haven't been progressed, and it's something that we would be really calling for and we would be really supportive of.
Well, thank you, Natalie. Chair, I have a question for Kula, please, and this is in relation to the issue around the UN Convention on the Rights of the Child. Kula, you'll be aware that the Bill of Rights Committee has stalled its work, for want of a better phrase, and there's the potential that we won't get a Bill of Rights through within this mandate. And I know you've given evidence to that committee around that, and so I'm just conscious, we have an opportunity possibly here to strengthen some of the protections for women, and notwithstanding what you said to Pam about, we don't want this to become litigious for people to assert their rights, but is there anything we can do to strengthen this bill, for example, around the harmful practices that you mentioned there that we could possibly introduce? I'm just wondering if you want to speak to the actual human rights element of this. Thank you.
Paula, did you have anything particular in mind when you're thinking about that? Because I think, we've all talked about how the bill can be strengthened. What particular right were you thinking of here?
Well, it was the stuff you talked there about in the full range of harmful practices. It's more just that sort of element of the convention around just the protection for the child in that regard.
So I think I know where you're going with this. So and I'm very happy to answer that question. So as you know, I'm very clear that the Bill of Rights in Northern Ireland is an incredibly important development, and the fact that we have been waiting for so long is a disgrace, and we, none of us, gives us no cause to be proud or complacent. My view is that the Bill of Rights in Northern Ireland should fully incorporate the UN Convention on the Rights of the Child, to ensure that children have all their rights in legislation, so that they can have better outcomes. We know the UN committee, and that would then mean that we listen to what the UN committee say and implement their rights. I'm assuming what you're referring to is the UN committee's consistent, since it was established and since it started examining the UK government and the Northern Ireland government, de facto the Northern Ireland government has consistently said that we should ban the defence of reasonable chastisement to an offence of common assault. I assume that's what you're talking about when we're talking about harmful practices. And that should have happened years ago in Northern Ireland. 2006, when the defence was introduced, that was a disgrace, and it's not something any of us should be proud of. We should then take any legislative opportunity that presents itself to introduce an amendment that repeals that bit of the miscellaneous provision. You will be aware that both NICCY, NSPCC, and a range of other NGOs have actively worked to get an amendment put in the current sexual violence and trafficking order that's going through committee stage through the Justice Committee. We still believe that in view of potential amendments around positions of trust, that there is scope within that bill to include such an amendment. It's a straightforward amendment. We also believe that this Assembly will follow what the people of Northern Ireland have been telling us since 2017, that by a sum of 67% are in favour of a change in legislation, and that's probably increased since in the last 4 years. So we should, I suppose what I would say to you is we should take every opportunity, any opportunity that presents itself, to get to protect our children from this sort of harm, because we know that physical chastisement in this way can, not always, can lead to physical harm, can lead to children being placed on the Child Protection Register, can lead to aggressive and antisocial behaviour, does upset and frustrate parents, and also that there is no evidence that such behaviour actually does any good. And if we have all that evidence staring us in the face, I don't understand why we do not protect our children.
Thank you, Chair. And it wasn't necessarily a politically loaded statement per se, and I'm not precious whether it goes through the Justice Bill or whether it comes through this bill. I'm not sure whether it falls within the scope of either, to be honest with you, any consultation I've had around it. However, I think that possibly what we could look at as a committee, or the Justice Committee, would put an onus on that relevant department to consult if it doesn't fall within either bill. But it's certainly something on my radar. I have another question, Chair, but if you have time at the end, I'll come back to it.
All right, okay. Thank you, Paula. So I'll move on then to Colin McGrath. Go ahead, Colin, please.
Thank you, Chair, and thank you to both of the presenters today. We appreciate hearing the updates, and I've got a question maybe just for each. Maybe, Natalie, if I could start with yourself. It's really, you had suggested in your written presentation about the Trust should have a statutory duty to provide that specialist support. Maybe just, could you give us a sense of what there is at present and what's missing, and then maybe just your assessment of how we could use this bill maybe to try and strengthen that?
Yes, certainly, Colin. I have had a look. I mean, NSPCC, as I said to you in our oral evidence there, we do provide a service, Domestic Abuse Recovering Together, our DART service, and it's really successful. I mean, NSPCC is very evidence-based in terms of the services that we provide, and everything's evaluated, etc., and it has been very successful in terms of its outcomes. The way that service works is there's a number of sessions where mothers and children would meet for 2 hours, weekly group sessions, and take part in activities in separate groups. And they talk about domestic abuse, the impact on children. They do activities together to understand domestic abuse, understand how they're feeling, and keep themselves safe. And And it is really about building that relationship back up again, because we have lots of evidence which shows that children recover better from domestic abuse where they have a stronger relationship with the victim survivor of abuse, and that's generally the mother. So that's the focus of the service that NSPCC offers. Currently we're only offering it in our Belfast office in Northern Ireland, and it's unsure whether we're going to be able to continue with that long term, and we're looking at that. But in terms of other services that are provided for child survivors of domestic abuse, it really is quite a varied picture, Colin, varied support. I had a look on a number of sort of websites, and there are some services for children, but it depends very much where you're based. It is very much dependent on the relationship that charities or organisations have with their health and social care trusts. So it's a tapestry of services. The support for children is dependent on funding relationships, very varied. No central support as such, and funding is piecemeal. So it does tend to be the case that individual groups are making bids to, funding bodies and delivering programmes of a sort, but it is unclear in relation to the extent of the evidence base around that, Colin. And to be fair, that isn't good enough for children who have suffered domestic abuse. We know the impacts. Evidence is absolutely clear about the impact of domestic abuse on children's lives and the outcomes in their lives. And if we are genuinely wanting to be trauma informed and respond to their needs and respond to, I suppose, the impact of the trauma that they have suffered, we need to have access to specialist support services for children, which automatically kick in. We can't have on the one hand a recognition, a statutory recognition in our children order that the harm caused to children by living in a home where domestic abuse occurs is actually harm, without having some kind of a corresponding obligation on government. And I suppose that's where we would like to get to, is a much greater focus on recovery, so that there is a clear duty to step in and to meet those children's needs. And where you recognise harm, you have to then have a corresponding response to that harm. And that's what we would like to see happening.
Okay, so it's almost improved services and consistency across the board then. Absolutely. To try and see how we can access those.
And guaranteed access, yeah.
Okay. Chair, anytime I've described the Children's Commissioner warm and fuzzy are always the terms that I would have had way up there. So I was delighted to hear those reference points again today. But maybe there's two things, maybe, Cuala, just to check in. Again, I think it is just sometimes the importance of a single word in terms of duty and promote. And I suppose that's maybe where there's the power of the committee in terms of making an amendment to change that word. But I was just wondering if you had any other examples of where there's a strong duty to be carried out and the impact that has versus a promotion. And also, again, with Paula's answer, you referenced a bit more about in the paper about the full range of harmful practices. I know sometimes whenever we talk about rights and charters, we all know what we mean, but the general public, they don't understand what that is. So if there was maybe some examples of what those harmful practices are, so that people can get a flavour of what it is we're trying to maybe amend here.
Okay, so I think, thanks for that. And I am warm and fuzzy. I'll have you know. So maybe, this, I just thought Hansard here. So as you say, it's interesting because we have been in front of the Education Committee to talk about the word promote, and the committee has been concerned that the word promote is too strong in relation to the integrated education bill. But actually, it is a woolly word. So when we're talking about statute, we need to have words that are very clear. So I haven't done a search. I should have done the search Natalie did to look at May's. To look at how many times words like may are in it. So we identified in clause 125 where it says the department may make regulations around standards of accommodation. Actually, they should make regulations. So as we've already said, the department shall by regulations impose requirements. So I think there is no point in having legislation if you're not using the words that are quantifiable. And that's why, again, I do welcome this idea of trying to codify what it means to be a corporate parent under those principles. And I can't remember, under 123. The problem is the way they've done it is they've put the principles down, which are great, and Natalie's recommend, but they haven't said how we are going to implement that, how a child is going to know that they've experienced their best interest, that their voices have been heard. And that's the essence. So whether we do it in regulations or whether you do it on the face of the bill, I'm not sure. But I suppose my advice would be take out look at every may, and should it be a shall? And I've learned this from 2003 when we were doing the Children's Commissioner legislation. Little did I know I would be trying to implement it. But mays are not helpful in law. Shalls are, particularly when you want to hold people to account. When talking about the breadths of harm, I suppose the only thing I would say is that under 166, where we talk about, well, we quite rightly and welcome putting FGM protection orders in. That is implementing a recommendation from the CEDAW committee, and they've identified other possible harmful behaviours such as child and forced marriage, such as polygamy, such as crimes committed, so-called honour crimes. So we do need to be sure that when we're looking at definitions of harm and when we're looking at how we protect our children, that we are understanding where they are likely to be harmed in 2021 going forward, and again that includes online harms, but I know that the work is being done across the water around that. So that's just some of the things, Colin, that come to mind, but again we can have a think about it and maybe come back to the committee.
Okay, thank you, Chair.
Thanks, Colin. And then Tama Golgaji Carol Nichillen. Carol Lanaray Lesh de Kest Lidahol.
Gurmagad Caherly. Thank you, Natalie, and thank you, Kula. So I want to go to clauses 122 and 123 and 133. Just, we've already been discussing definitions of harm and that. I mean, it's certainly in terms of physical harm to children. I hate using the word smacking because it almost undermines the impact and the trauma, but I do think it needs to be legislated for. Absolutely do. And it would be preferable if the Justice Minister could lift that and take that. But if not, we should try and do something because it would send out all the wrong messages. So that's my own view. In relation to, I completely agree with Kula in relation to the may and shall. It's one of the first things I learned when I went into the Assembly. May means if the Minister's minded to do it or the department, well, they're the same thing. And shall means they must do it. So, I mean, in relation to this, I completely get that. The other aspects of those clauses that I've raised concern me in relation to the codification of corporate parenting. So, for example, children who are in residential care, we have a couple of residential care providers in my own constituency, and I remember a long time ago that there was issues around particularly teenage children, young people leaving the residential care to go into the cars of people who were causing them harm. And it was almost literally the social workers done everything, bar jump into a car to get them out. And then when it came to the police to get them back, there was always a vague area there about if a crime is committed or not. So, in your opinion, is this bill an opportunity to strengthen those protections for those young people? That's the first question. And then the other aspect that I want to talk about is in relation to the consultation with children with disabilities and parents and guardians and carers in relation to this as well. To ensure that there is a duty rather than regulation. And we are looking at autism, just one example, but there are many others where services provided for children and young people are almost depending on how good or robust the trust is. So it's just to get that view from yourselves. And then the last thing I'll say is that I do believe that we do need a statutory duty on the definition of harm for trusts because we've used the example of domestic violence. But when it comes to, as Natalie and Kula, you both have outlined, getting the right support at the right time, it is very much piecemeal. I know myself, some of the people who work in the trust are really, really good people. But the system in which they work in is so convoluted and complicated and bogged down with bureaucracy that I just go straight to the community and voluntary sector as my first point, because I want to get the right help at the right time. And at the same time, parallel to that, try and get them help from a statutory basis. And that is really difficult. In 2021, it is really, really difficult. And COVID, as an example, has compounded that. So just to make sure that when it comes to any of these clauses, if there's anything that we've missed out, it would be really good to let us know. And finally, Chair, the point of
let's take those ones, Carol, because I need to be fair to other members as well.
Okay.
Let's take those ones. And I'd say to members, if there are additional questions, and I know there has been some indications, send them to the clerk and maybe we can forward them on to so I'll go back to the panel there at that point. Thank you.
Okay, I'll very quickly jump in because I think, Carol, it's hard to disagree with anything you've said. When you look at 1, 2, 3 and you look at corporate parenting principles, I go back to what I said about this. This was where my warm and fuzzy comment came in, but I'll go back to what I said is that it's fine, but it is how we implement them. The corporate parent is, who is the corporate parent? Is the corporate parent the trust, or is the corporate parent the statutory agencies who are tasked to protect the children? That includes police, that includes education, that includes the justice system. So I think when you're beginning to look at who is the corporate parent, I think that's when we look at who has a duty of care to children. What I would say about PSNI, particularly with regards to when they're discharging their safeguarding role rather than their detection of crime role, I think they have travelled some distance to get closer to discharging that safeguarding role. So I'm not sure that there's anything in this bill that I would want to see around PSNI. For me, it's a matter of ensuring that they understand their safeguarding role, and that they understand that they do have certain powers if a child is at risk. So and like I said, those conversations have been ongoing with PSNI. What I also want to say, so moving on to services and the provision of services, particularly for children with a disability, coming out of the pandemic, and I have said this a lot, during the pandemic and coming out of the pandemic, when we look at how we served families of children with disabilities across the piece, it is for me the biggest shame of our system. Coming out of the pandemic, and those parents predicted it back in 20th of March 2020. What we have seen though, what we are seeing is a system under enormous pressure. Carol, it's not a system that doesn't want to respond, it's a system that isn't able to respond at the moment because of the pressure. So when we're talking about health, and this is the big thing, I suppose I want to say to this committee, when we're talking about health reform, we cannot forget about the reform in children's social care, particularly, but not exclusively, services for children who are cared for and children with disabilities and special educational needs. Do I want to see a duty to assess and to implement the outcome of that assessment? Yes, 100%. That is a flaw in the children order, and that speaks to what Natalie was saying around domestic children who are victims of domestic violence. I suppose I would say that for every child who is deemed to be a child in need and a child so there is a duty to assess, but not a duty to provide, and we need that duty to provide, I suppose, is what I would say. And I can see the chair getting a bit nervous about time, so I'll say no more.
Okay, and Natalie, then, do you have anything you want to add to that?
Just to support what Kula has said, Chair, and also to reiterate as well NSPCC support for movement forward and legislative reform around equal protection. We are way behind in terms of equal protection, and I don't want to take up a huge amount of time today talking about it. And I do believe that we need to make progress around equal protection and the abolition of the defence of reasonable chastisement, because it really is a public protection issue when it comes to children and young people. The fact that we are allowed to assault children and they don't currently enjoy equal protection as adults from assault is really, really quite awful in this day and age, and particularly given the impact of the pandemic on children and young people. The 62 countries have changed the law and we are way behind, and this is something that we really, really need to see progress on now. And I suppose the issue for me is that it's not effective in changing children's behaviour. Also, it's incredibly damaging to children. We have seen huge swathes of evidence coming forward about the impacts of physical punishment on children's mental health, cognitive development, etc. And also, it is one of the key risk factors for physical abuse. So there is an obligation on us all to ensure that we do whatever we can, whenever we can, and as urgently as possible, without putting pressure on anybody or falling out about what comes within and without scope in various pieces of legislation. But this is absolutely 100% about protecting children, and I couldn't agree with you more, Carl. I think we need to move on this, and we need to move on this immediately. So if there was any potential for equal protection to be considered within the scope of this bill, I would urge the committee to do whatever they can within their power to move this forward, to protect our children, because it is absolutely vitally important, and I don't think we need to rehearse the reasons why today. But
Thank you, Natalie. And going then finally to Orlia Flynn. Go ahead, Orlia, please.
Thank you. Sorry, it took me a wee while to unmute there. So Colin and Carol have already actually asked 2 of my 3 questions, but maybe just to go back to them just quickly. On Colin's question to Natalie around that the statutory duty on Health Trust to provide that specialist domestic abuse support. And I do think, Natalie, that is really worrying around, the fact that there is then clearly a postcode lottery as to what services people are entitled to depending on where they live. So I just wanted to ask as a quick follow-up, has that statutory duty been implemented elsewhere in terms of those specialised services? That's my first question to Natalie. My second question that Carol just touched on there to Kula, around the codification of corporate parenting responsibilities. And this might be something, Kula, that yourself and Natalie might want to come back to in writing to the committee, but it was just actually to ask for if you have any practical suggestions as to how you could actually provide more detail on how you hold those corporate parental responsibilities, how you hold that to account. So if you have any practical suggestions, because I know there is some issues you were saying, around for example, the trust and the PSNI. And then just finally, maybe a question to both presenters. It was around clause 121 and the short-term breaks. And I think it was in Natalie's briefing note, you were talking about broadening the scope of the definition of what the other categories of children are, or who they could be involved in getting those short-term breaks. And I was just wondering if you have any thoughts on what that broader category of children could include. I know Natalie had included in her written correspondence, she gave the example of homeless children, 16, 17-year-old young people who are homeless could be included in that. And I'm just wondering if you can be any more specific in who that brand of young people, who else that could include. Thank you.
Thank you, Orlia. Yeah, go ahead, Natalie.
I suppose I'll come in on that one. Just in terms of the duty around on health and social care trusts that we are proposing, Orlia, there isn't. We've been working very closely with our colleagues in England and Wales in the development of the domestic abuse legislation over there. There is a similar duty, but it's not exactly the same. In England and Wales, their domestic abuse legislation places a statutory duty on their local authorities to provide support to adult and child survivors in accommodation-based services. That, I suppose, isn't what we're looking for here, but it would be a similar duty. It's a very similar duty in that it places a statutory obligation on their equivalent of our health and social care trusts. So we would like to see a similar duty, but focusing on those specialist services and on that recovery for children, because all of the evidence shows us that that's something that we don't have across the board in Northern Ireland, and it's something that would make a massive difference to children in terms of their recovery and their future outcomes in life. So there are places that we can look to for similar duties, but we would like to see that tweaked for Northern Ireland to reflect what is missing here and the particular circumstances here. In terms of practical suggestions around corporate parenting, I did refer to the Scottish legislation there, 2014 legislation, and they produced a really comprehensive guide, which I'm happy to forward on to the committee, which outlines how we might define and how we might determine what the obligations mean in terms of these corporate parenting principles. It's definitely worth having a look at, and it's definitely worth us, I suppose, as a society, having more conversations. I mean, there's lots and lots of places that we need to work on in the future to get to the end of the discussion within this bill. As I said, loads of it is to be determined down the line in relation to regulations, rules of court, guidance, etc. The corporate parenting principles is one that I see that we absolutely need to get to the bottom of in terms of what we mean by that. What are the actual obligations on the trusts here? What are the consequences if they're not complied with? And we do have Scotland to look to, and so I think that would be a really excellent starting point. In terms of the short-term break question, the short-term breaks one is one where I had made some suggestions just from my own experience of groups of children and young people who I felt might benefit from the short-term breaks, and having conversations with other I suppose, contributors who are interested in the development of this bill. We felt that homeless 16 and 17-year-olds may be one group who may benefit from being able to access these short-term breaks, particularly where time and accommodation are required to allow for an arrival at a permanent solution. Also, children requiring post-adoption support and children who are on the edge of care, that kind of step up, step down support, that we have more flexibility across the system. I think that fundamentally goes to the heart of where NSPCC would like to see us in terms of our response to children, and that is meeting children wherever those children are. And the short breaks one is a really good example of that. It's where the system should be able to respond to meet the needs of children for short periods of time, to provide them with that support if that's something that would be helpful for them. I do think there needs to be ongoing engagement in relation to who those other categories of children are, and that we should be consulting on this to make sure that we're not forgetting about other categories of children that other organisations may immediately think of that I wouldn't think of, to ensure that all children who require this support are included so that they're able to access that. And that's a conversation I would very much welcome and like to be part of.
Thank you. And Cuala?
Yeah, I'm just gonna, because I think Natalie's answered the other questions. But 1, 2, 3 around corporate parenting principles. How do you prove it? And I think you prove it by engaging with the young people who are experiencing the services. We've been doing a lot of work with the departments around child's rights impact assessments, so that everything they do, they understand children's rights. But if we're talking through this bill and through other things around good advocacy services, I also note they're not publishing a children order report. I think that needs to be looked at, because in the publication of a report on the implementation of the children order, what I would want to see is a comprehensive review from children and young people themselves as to how they experience these 7 principles on an individual basis, but also then collectively, so we can look at reforming the services. If they're not in a realistic way, in a proper way, because it's the chips for tea. Just because a child says they want chips for dinner every night doesn't mean it's in their best interest. So we do that whole balancing thing. But for me, that is how you prove. You ask the young people who are experiencing those services if they are having their if they're being promoted with high aspirations to seek and secure the best outcomes, if they're in a safe and if they feel safe and have stability in their home lives. That is how we evidence whether these corporate parenting principles actually make one jot of difference to the lives of children and young people.
That's great. Thank you very much. Thank you both.
Okay, thank you, Arlea, and thank you both as well. Just a final wee quick one from me, if you can. The issue has been raised around kinship adoptions and kinship fostering, and the benefit of those, and particularly I've raised it particularly around the issue of cross-border. Living here in a border community myself, we often see families living potentially on the same road, but technically in a different jurisdiction, or even indeed on the same farm and protection. Do you see value in terms of us doing everything we can to ensure that kinship adoptions are as available as possible and are in the child's best interest?
Just very quickly, and this speaks to some of the work we've done around Brexit and cross-border communication, that geography or jurisdictional issues should never interfere with progressing a child's best interest. And we know that kinship care, fostering kinship adoption are often the best outcome for children and young people. So absolutely, it is my understanding that we are looking at cross-border, particularly around health and social care, that where people can get in a car, a train or a bus to reach the service. It's much easier than getting on a plane or a boat. So I would always advocate for strong links across the border as well as across the sea.
Yeah, and from your perspective, Natalie?
Yeah, I mean, I would support that. I know, Colin, that the Department of Health had been looking at kinship, and I know whenever they gave evidence to the committee, they said that they had looked at kinship orders and felt they didn't fit for Northern Ireland. It is an area that I would like a bit more information on from them as to why that is the case, because we know that the majority of children who are not living with their parents are in kinship arrangements. So it's something I know that the Children's Commissioner has been working on for some time in terms of it is for us, Colin, it is very much a case of meeting the children's needs. That for us is the bottom line. And kinship arrangements work really, really well. And it is, I suppose, about formalising that a bit so that those carers do get the support and I suppose the help that they need. So yes, there is huge value in kinship arrangements, and I would completely agree. As long as they're seen to meet the children's needs, that's fundamentally what we're all, I suppose, about. And this is part of the solution. Yeah.
Okay. Listen, thank you very much both for attending this morning and for that session. Some really useful perspectives and some very useful suggestions. There are a couple of outstanding questions there from members, and indeed I have one myself that I haven't had time to put on the. But if you're content, we'd appreciate if we can forward those via the clerk. Absolutely. And maybe get a response from you to factor Absolutely. In. But for now, good luck, and thank you for attending and assisting us this morning. Thank you.
Thank you, Colin. See you.
All the best, Natalie. Okay, Carla.
Bye.
Okay, members. So I think one of the things that clearly comes across in the session and has come across, I think, in several of the sessions was done, is around the issue of experiencing domestic harm and the definition of that. Would members think it a good idea at this point that we write to the department and ask them if they're considering any amendments in relation to that, so that we can then consider how we might move forward? Would members be content with that as one suggestion? Yeah. And then Paula, go ahead.
I just want to know if we can get an update on where the draft foster care regulations are as well. Thank you.
Thank you. Yeah, and if there's other questions, and I do have one or two there that I would have liked to put myself, but time didn't allow. But if there's other questions, could members forward those to the clerk, and we'll forward those on to NICCY and NSPCC, and maybe get the responses back from them that way. Okay, members, I'm going to take just a short break there because the next session is quite a big session as well. We have a lot of members on the panel. So we'll take a short break there just to allow members to refresh and maybe suggest a 10-minute break, and we'll resume at 11:05, please. Thank you.
Okay, Chair, that's us back live now.
Okay, thank you, Clerk, and thank you, members. So we will now resume at item 6 there, which is a briefing on the Abortion Services Safe Access Zones Bill. And today we are hearing evidence from the Health and Social Care Trusts. So this is a second of our evidence sessions on this bill, members, and I refer you there to the written submissions at tab 6 of your pack. And I'd now like to welcome by Starleaf, Miss Heather Jackson, who is Interim Director in Trauma, Orthopaedics, Rehab, Dental, ENT, Obstetrics and Sexual Health. And Mr. Colin McMullen, who is Co-Director of Maternity, Dental, ENT, Gynae and Sexual Health Services. And finally, from the Belfast Trust, Dr. Siobhan Kirk, who is Associate Specialist in Gynecology, Clinical Lead in Sexual and Reproductive Health. Then from the Northern Trust, we're being joined by Claire Galloway, and Claire is Head of SARC and Sexual Health Services. From the Southern Trust, we are being joined by Dr. Caroline Hunter, who is Lead for EMA Pathway, and Caroline Keown, who is Assistant Director for Integrated Maternity and Women's Health. From the South Eastern Trust, we have Kieran Quinn, who is the Interim Assistant Director for Women and Acute Child Health. From the Western Trust, we are being joined by Maureen Miller, who is Head of Midwifery and Gynecology, and Hilary Campbell, who is the Lead Nurse for Public Health. So clearly that's a very extensive panel, and we will have some difficulties in managing that. But if I could ask members if they have a question for a specific trust or a specific individual, if they know who they wish to pick up the question, please indicate. And if not, then I may tic-tac with Caroline Keown there in relation if she wishes to, if she thinks it would be effectively directed to some of the other panel members. And if panel members indicate with a hand on screen, then in relation to your question, I'll try and pick up on that. But it's difficult with a dynamic session as we move forward. So we'll work our way through it. But for now, I'll go back maybe in the first instance to Caroline Keown, just to check that we have Caroline online successfully and that you can hear us okay, Caroline?
Yes, Chair, I can.
Yeah, so we're hearing you there, Caroline, but not seeing you just at this minute in time. I'm not sure if there's anything in your settings you can do with that, but I am hearing you, which is the most important thing. So, Caroline,
I'm experienced just some technical issues this morning, so it may well be that it'll be just audio only, so apologies for that.
Okay, and the audio is a bit haphazard there as well. Caroline, if you happen to have access to headset, that normally helps. But also, I want to say to everyone on what is a very large panel and members, if everyone can go on mute when you're not speaking, that will help with the sound. And if everyone, where possible, if people can use headsets, that will also assist with the sound. So apologies, my camera was off for a large part of that as well, but I think I'm back on track there now. So Caroline, hopefully we can hear you a little better now, and I'll go back to you for opening remarks, and then we'll go to members' questions. Thank you.
So, Chair, is that a little bit better?
It's a little, but it's not great, Caroline. I am a wee bit concerned about it, particularly in light of the fact that you're doing the remarks for all the trusts. Let me try it again there, and I'll let you run a little bit this time to see how we get on with it.
Chair, the other four trusts do have the opening statement, so if it is easy, or one of my colleagues maybe will assist me by sharing the opening remarks.
Well, I think we will need to. I think we'll need to. Your sound is quite poor, Caroline, unfortunately. So can I ask one of the other members to indicate who would like to pick up on that, to maybe go through the opening statement, and then we'll go to members? Siobhan, Dr. Siobhan Kirk, you're the only one I'm seeing at this point in time. Would you be willing to go ahead with the opening statement?
I haven't seen the opening statement. I'm sort of an extra add-on. I can ad-lib if I have to. I don't know whether Heather Jackson or Colin McMullen are on from Belfast Trust. I know everybody's been having great difficulty getting on to Starleaf. It's not something we've ever used before.
Okay, so I do see Hilary there online, and I'll check with the clerk. Clerk, do you have any indications coming in from any of the panel there in relation to this?
No, Chair. I can see Hilary's on, Dr. Kirk's on, and then Caroline's on. There is somebody else in the audience whose mobile phone number is showing, so we can't bring them up into the panel because the mobile phone number would show. So at the minute it's just Siobhan, Hilary and Caroline on.
Okay, so Hilary, I'll go back and check with yourself there. Caroline has advised that some of the other panel members may have access to opening remarks. Do you have those, and are you able to go through those for us?
Good morning, everyone. My name is Hilary Campbell, and I'm a head of service for the Western Health and Social Care Trust. I've been asked to attend this meeting, and I don't have those opening remarks. I'm here on behalf of the trust to give some evidence was what my role was. I've had a few problems getting on. My colleague Maureen Miller from Midwifery is hoping to join us as well. She is in the room. I'm not sure why you're not seeing her. I've just contacted her there. But that really was my role for joining the meeting.
Okay, well, listen, what I'm going to suggest then is that if we maybe go for some opening remarks from yourself, Dr. Kirk, in relation to, and I appreciate that you don't have the remarks in front of you, but if you want to set out some of the context, then we can see if that will allow us to bring other members online as we go through. So we'll go back to yourself, Dr. Kirk.
Okay, thank you. And on behalf of all the trusts, we're delighted to be able to, well, at least attempt to try and come and talk to you about this. All trusts are very supportive of the Safe Access Zone bill, and all, as you're aware, have submitted some written information. There's also been written submission from other organisations, including two that I'm involved. I'm a fellow of the Faculty of Sexual and Reproductive Health and the Royal College of Obstetricians and Gynaecologists, and they've also submitted a joint response on the bill. As you know, since April 2020, the majority of trusts have been providing early medical abortion service, and the majority of trusts have also been victims of protests outside the clinics, all actually except the South East Trust. This has had a significant impact on staff, patients accessing abortion care, and also patients accessing other healthcare within the buildings. Also staff and passers-by and other, particularly in Belfast, in our College Street clinic, local businesses have also been affected. This has really become an issue since the beginning of January 2020. And most clinics do have at least weekly protests. They tend to be from two separate groups, Precious Life and a group now called Abolish Abortion, NI. Two of the trusts have had to move their clinic locations as a result of significant harassment and intimidation, not just to the staff, but the patients. In Belfast Trust, we've had to employ a security guard. We've had to blacken out our windows. We've had to contact the police on several occasions due to intimidating, aggressive behaviour. There's obviously effects on the patients accessing care, are very distressed. Some of these women are very vulnerable and an state of emotional distress to start with. It has effects on the staff. It's not nice coming into work and being called a murderer, having the entrance to your work premises blocked, having holy water thrown, threatened to be recorded. This happens to staff and patients. And not all the staff working in these clinics are actually involved in abortion care. Some of my staff are conscientious objectors, but they still find what is happening outside the clinic absolutely abhorrent. Patients are coming in a very distressed state. We've had a couple of women who've come in accessing healthcare for investigation of abdominal pain. One of them had a ruptured ectopic and had to go straight to admission for theatre. The other one had to have an operation on her ovary. And they actually spoke to the police, and if they had have turned away when they saw the protests and hadn't accessed care, there could have been very serious consequences. the protesters say that it's peaceful and they're praying and they're offering support, but some of their behaviour is quite aggressive, and there have been examples of that in some of the written submissions. They don't know what circumstances these women are in. We had a woman a couple of weeks ago who's been diagnosed with terminal breast cancer. After becoming pregnant with a planned pregnancy, and she was very distressed at the fact that she has to have an abortion to try and give her the best chance of survival because she's starting chemotherapy. And they were particularly aggressive and abusive towards her, and the police were involved in that case. We have a lot of vulnerable women who are asylum seekers who've been, with one recently who was sexually assaulted on their way here from Eritrea. And she was already very distressed at having to come for this treatment and had significant harassment outside. Sorry, I may be going on a bit. I'll stop there. I see Colin McMullen has joined us from Belfast Trust too.
Okay, well listen, and I have to say that in itself is quite a stark and a shocking opener, I have to say, in terms of an evidence session to this. And I'm very conscious that we are talking here about women and children accessing services. We're also talking in some instances of people who, as you say, are accessing other services. But also, I take it that this will be impacting, without the protesters necessarily knowing, people who are trying to continue with the pregnancy, maybe a very difficult pregnancy, but have made that decision and are seeking help. They're also getting caught up in all of these protests. So I think I have to say, I think it's actually, some of the things you have mentioned already there are absolutely disgraceful and unacceptable, that people are being subjected to that level of harassment and abuse. And I suppose my first question then to yourself or any of the other members there, Siobhan, is around what your view would be in terms of the definition of harassment. What should be included within that definition of harassment from your experience of witnessing some of these so-called protests? And before I take in your answer, I want to say I absolutely believe in people's right to protest, but I think what you're describing there goes well beyond. And I think as a mature and a civil society, we should be able to recognise the difference between potentially assault and harassment and abuse and the legitimate protest that people may want to undertake, which no one is seeking to, or that I'm aware of, is seeking to undermine. But so around the definition of what should be included, what's your views, Siobhan?
Well, blocking the entrance to a clinic for a start is harassment. Even seemingly innocuous behaviour like standing quietly and handing out leaflets. Some of the leaflets that are handed out are completely medically inaccurate. Suggesting that there's abortion pill reversal, which there isn't, and it can actually be dangerous. Some doctors offering this have been under GMC restrictions. Some of the leaflets suggest that abortion causes breast cancer, which is absolute nonsense. Even just being looked at and watched coming into the clinic, that's, all women and people have a right to safe local access, and it should be confidential. Any healthcare should be confidential, but particularly sexual healthcare and abortion care. And, these people are just standing, seeing everybody going in and out of the building. So for some women, even just being watched and looked at is a form of intimidation. Occasionally, they're grabbing their arms, they're opening up handbags to force leaflets in. There's some of them wear body cam and video, which is quite distressing for women to think that they may actually be filmed going into the clinic, and this could potentially be shared on these organisations' social media pages.
Yeah, no, listen, that's extremely concerning. And I am genuinely shocked at the idea that someone who has been sexually assaulted should be forced to run a gauntlet woman or child. And I'm deeply conscious as well that staff are being impacted here as well. I'm not dismissing that, but I just think it's absolutely ridiculous. Do you see, in terms of then what you've said out there around that, have you any view? And I know it's quite a difficult question, given that a lot of the services are site specific, and I think that's an appropriate response to take. But in general, would you have any view, or any of the other panel have a view around the size that an exclusion zone should potentially be considered?
Well, I think the RCOG and the FSRH, and I think in the Belfast Trust statement as well, we suggested it should be 150 metres, which is what it has been in some other countries that have introduced this, such as Australia and Canada. Women need to be able to access public transport and safely get to their car or get away from the clinic. Maybe somebody else wants to come in there.
Well, I do know that Colin McMullen is looking to come in there, so go ahead, Colin, please. Yes, go ahead, Colin.
Hi, thank you. I'm a co-director in the Belfast Trust. I have a difficulty joining. I'm just on my mobile, so I hope you can hear me okay, Mr.
We're
Chairman.
hearing you, yeah, we're hearing you.
Yes, I would just echo what Siobhan has said, and the forms of harassment. We have had occasion when women are leaving our clinic and they've been, the protesters have been walking beside them and following them up the street. And again, not in any way shouting or as they sometimes do, or spit as they sometimes do, but just, talking to them, but walking alongside them, which is, of course, is harassment again. So we believe the exclusion zone of 150 metres, particular to our clinic, which is in College Street at the back of Boots in the city centre, we would want our women to be able to access public transport and the glider or the buses at the City Hall if they had to, without being accompanied and the protest following them. So I think that's very important. And just as a bit of a context, we asked our team to start recording the incidents on our incident management system, and we've recorded 41 since March, which I don't believe is anywhere near the total amount of incidents that have actually occurred. But 41 have been formally recorded since March in what is a weekly clinic.
Yeah, thank you, Colin. Listen, I'm going to go across then to other members, and if panel members can indicate there to the clerk if they're wanting in on a particular issue, that might assist with it. So I'm going first of all to Deborah Erskine. Deborah, go ahead, please.
Thank you, Chair. And can I just say, Dr. Kirk, that was a really stark and really important that we as a committee got to hear those examples. And from the outset, can I just say that abuse and harassment at healthcare settings is wrong, no matter what the healthcare setting is. And, this is obviously a very sensitive situation. It is a sensitive and emotive topic. And nobody deserves to go to setting to be subject to upsetting comments or anything like that. And I think the key is compassion here too. Several pro-life groups, have affirmed this in their submissions, to the call to the committee for evidence. And I think we can agree that we can't tar everybody with the same brush, if they are from a pro-life organisation. But just a couple of questions in relation to the bill. What discussions may have taken place with the trusts, with the police as well, on the viability of the provisions of this bill? Do you think that buffer zones may displace protests elsewhere? And what implications may that have for other parts of your estates and even your staff? And also, and this is my last question, just do you think that there may be a continuous police presence on your estate to enforce the buffer zones?
Well, we've had quite a lot of discussions with the PSNI in Belfast, and they are very supportive, and they are aware that on Thursdays this happens. And they do walk around regularly, and we have contact numbers, so a very good relationship with the PSNI. But at the end of the day, they say it's not their responsibility, actually. And they would be very supportive of buffer zones as well, because, the police are busy doing other things. They can't stand outside our clinic continuously. I don't know, in other trusts, Claire Galloway might want to come in other trusts, they have moved the location, and I think this has helped rather than cause other issues, Claire.
Yep, go ahead, Claire.
Thank you, Chair. Thank you for the invite this morning. Yes, we have had to move locations at least on 2 occasions. So within the Northern Trust, initially our clinic was facilitated in the Ballymena area. We then had to relocate to the Coleraine Health Centre, where weekly protests continued up until the end of June. The incidents had been escalating. We had about 15 incidents where the seriousness of the incidents were escalating so much that we went back to senior management team within the Northern Trust, and they then approved that we could relocate back into a hospital site. Now, since we have moved back into the hospital site, there have been no further incidents. So really, for us, this was evidence really that these services should sit within hospital sites. Again, as Siobhan, the trends have been that since it would be protesters outside intimidating staff as well as clients, protesters using graphic images and language, also then the staff members of other services being distressed due to personal circumstances. Service users attempted to enter clinic twice, was blocked by the protesters who pressed a plastic fetus into her hand. These are all service users that have submitted official complaints within our trust complaints process, and been forced to take leaflets. And also, again, I would say with Siobhan, I am the head of service for the Rowan, the Sexual Assault Centre in Northern Ireland, as well as contraceptive services. And I would have to say, absolutely, that everybody has a right to healthcare, and especially those victims of sexual assault, as well as anyone else who chooses to access the service.
Thank you.
Chair, would it be okay if I just come back on a point there, Chair?
Go ahead, Deborah.
I'll be very quick. I mean, I suppose there, in terms of what you've said, Dr. Kirk, in relation to the police saying it's not their responsibility, will that still be the case is probably what I'm trying to get at, in terms of if a buffer zone was in place. Who then enforces that? Is that still going to be, your staff having to monitor, and things like that? And I suppose each estate is different and is going to have to take into consideration how big their buffer zones are. So that's what I'm really just trying to tease out there.
Yeah. Well, again, the ins and outs of that, I'm a clinician and I'm there to look after these women. The ins and outs of that are sort of beyond my control. But if it is legislation, then I would assume PSNI would be able to take action. They've told us at the minute that they can't. Harassment, I think, is defined, or you have to be harassed by the same person on 2 occasions for it to count as an offence. And unfortunately, these protesters have been at this game for a long time, and they know how far they can get away with things. So quite often a different one of them harasses somebody on the way in, and then a different one on the way out. Another thing I think I should mention is that sometimes women are recognised by these protesters because there's a clinic masquerading as an abortion clinic in Belfast, run by the same group of people. So women quite often access services with them, first of all, are forced to have scans. There's attempts to delay treatment. And then whenever the penny drops and these women realise that these people aren't going to help them access abortion, they turn quite nasty and they keep ringing them, swear at them down the phone. And then whenever the women have discovered where to access services, they could well come across these same people standing outside the door. So this is another big issue.
Okay, thank you. Okay, Deborah. Yeah, thank you. And go on to Paula then, and then I'm going to Alan and then Jerry. So go ahead, Paula, please.
Thank you. Sorry, there's a delay on unmuting. I have to say, I'm incredibly angry at the contribution so far. I have to say it's truly shocking. I didn't realise it was quite so bad, and I applaud your professionalism, all of you, in dealing with this. I mean, it is unbelievable that this is happening. A question I wanted to ask was in relation to the costs of having to relocate, of having to appoint a security guard, of having to record these incidents. You know, what is the hard cash cost, as well as, I'm coming on to the staff in a minute, please, thanks. Does anybody have a figure as it's been recorded, the impact on very, very tight trust budgets at present?
So I'll start first of all, Paula. I mean, we have tight processes in place already within the trust. So we have governance systems already in place. So in terms of electronic reporting, we submit through an electronic system, and then an electronic report is pulled. So in terms of resources, when it comes to report incidents, I don't know that there's a lot of resources used.
I think my question, I'll just keep with you, you know, in terms of actually, you know, relocating to a different venue, you know, there will have been a cost maybe in terms of, you know, getting the IT guys in, or, you know, that sort of, and then displacement. I'm just wondering, has that been evaluated?
Yes, I wouldn't have it to hand now, but yes, absolutely, I could submit some costs because we've had to relocate 3 times. So yes, IT costs, furniture costs, etc. So yes, I'm happy to submit some costs if required.
Okay, thank you. And I suppose I'll maybe move on then and ask if any of the trusts can identify costs to submit to the committee for the benefit of time. I'm just wondering, have staff, are we aware of any staff who've had to take time off sick because of the level of harassment, and also just the triggering impact of having to support women over and over again who've had to experience this? Again, is there a record of how much time staff have had to take off?
Well, there was one doctor that was providing the service who has since stopped doing, and I think that was partially due to the effect of the protests.
Okay, I suppose my other final 2 points are in relation to more comments, and I'm just asking the clerk if we can write to the minister to ask him what he is going to do about Stanton Healthcare in terms of it not being a regulated organisation. I think it's unbelievable what I have heard today. We've heard some things about it, but this just takes it to the next level. And the second question I want to raise is in relation to the bill. Does it include being spat on, and does it include being soaked in holy water? Again, we need to make sure that every single aspect of harassment is included in this bill. But thank you all for your service in this time of uncommissioned services. Thank you.
Thank you, Paula. And I do know that Colin is looking in, so maybe Colin can pick up on your question, as well as I think he wanted to comment on the earlier point.
Thank you, Mr. Chairman. Yeah, it was just a comment about the cost of having a security guard wasn't too significant. We have someone in place whenever the days the clinic's on, so it wouldn't be a significant outlay really for the trust. But in saying that, it's additional cost. There's a cost of time for our very dedicated clinicians spending longer with these women when they arrive for what we want to deliver: compassionate, high quality healthcare. And they're arriving through the door in a very distressed and emotional state. So there's a cost of time for the healthcare provision. In terms of relocating, Belfast Trust hasn't been able to relocate our services onto hospital premises. And I have to assure you, that is a massive, massive task. Our estate is extremely limited, and we're constantly struggling to find premises for new services and changes to services. And it's involved significant disruption of moving people about. So within Belfast, we're significantly restricted in that regard. If we had an easy solution, we would. So that would present a significant problem to us. And I would just like to, you know, as others have referred to, the dedication of the team. They're so committed to these women, and particularly the adversity that they face. There hasn't been too much staff absence due to it, because the team are just so determined to help them. Siobhan and her colleagues as across the trusts.
I appreciate that extra information. Thank you.
Okay, thank you. I will go there to Alan. Now at this point, Alan Chambers. Go ahead, Alan, please.
Thank you, Chairman. Certainly, nobody could condone any of the conduct that we're hearing about here this morning, and as the chair said earlier, the right to protest is an important right, but this behaviour goes way beyond what is acceptable. And certainly, I would want this bill to protect all staff and visitors to these centres in all circumstances and situations. Would any of the contributors this morning have any concerns that the location of these protests could shift if there were new laws brought in about safe zones around the clinics, that these protests could shift to maybe to trust offices or indeed even the homes of senior staff?
Yeah,
So, go ahead, Siobhan. Thank you.
Sorry. Yeah, threat to staff is very real, and we're all aware of that. You may be aware that in America, some doctors providing abortion care have actually been murdered. That's obviously in the extreme, but yeah, there's always a possibility. It's easy to find out who is involved. We've published scientific papers. None of us are ashamed about what we're doing and helping these women. So there is a possibility that we could be followed to our cars and be easy enough to find out where we live. So there is always at the back of our mind serious concerns about that.
Do you think that perhaps the new bill should possibly have something built into it to extend that protection? I know that earlier contributors have said that the current law against harassment law could come into play, but I'm not so sure that it would provide the protection. So I'm just wondering, do you feel that an additional clause in this bill around harassing staff in other situations, be it at their home, be it at their place of work, would be a useful inclusion in the bill?
Yes, I think it would. I don't know how it could be set out or what it would involve exactly. Obviously protests can happen anywhere really. If we do get the buffer zones, protests can happen anywhere else. So it isn't impossible that there could be a gang of them outside my front door someday.
Yeah. Thank you.
Okay, thank you, Alan, and Tommy Agdal and Nish. Good you, Jerry Carroll. Jerry, Dukesh Lidahall.
Yeah, good morning. Thanks again. I mean, you are in a way only providing basic healthcare, but you're doing it in a very difficult scenario, faced with very challenging and I would say grotesque behaviour from anti-choice activists. So thanks, even though what you are doing should be uncontroversial. Two questions. Are you aware, I suppose Dr. Kirk and Colin specifically, of anybody outside the Belfast site that have been charged for harassment or intimidation for this kind of activity, either specifically in Belfast or elsewhere? And also we had some briefing from the Human Rights Commission earlier this week, and they suggested about audio recording being included. So there's been cases where there's been noise playing. I don't know how to describe it, but basically very distressing sounds to intimidate, to try and guilt and have a real horrible impact on women. So has there been any kind of behaviour either outside the site specifically or beyond the 100-metre radius that's being suggested? So hopefully that's comes across okay, but I can clarify that if required. Thanks.
Thank you, Jerry.
I'm not aware. Sorry. I'm not aware that anybody has been charged. A couple of weeks ago, they were given a warning, I think, for antisocial behaviour, but that's as far as it has gone from the police, as far as I'm aware of. I know in other trusts, sometimes there has been significant noise problems with loudspeakers. I think one of the organisations had loudspeakers. I think it was in the Northern Trust. and they were, particularly targeting the doctors and suggesting that their souls were damned, and a lot of sort of hellfire and brimstone. And that was in a health centre. There were health visitors working in there, there were GPs working in there, and everybody could hear it. I haven't actually heard anything outside in College Street, but we've got old brick walls and we're sort of further down the back, but I haven't heard any actual shouting or loudspeakers outside College Street.
And Colin, I think, yeah, go ahead, Colin.
Yes, thank you. When we met with the PSNI in Belfast, they were explaining the definition in the legislation around harassment, and they explained that unless there's physical, unless, as Siobhan alluded to earlier, unless it's repeated, the same individual targeting an individual more than twice or more, then it doesn't constitute harassment. And they're very clever, the protesters, at staying within the confines of the law. So throwing the holy water and is sometimes they're going over the line a little bit. But the other element is the PSNI confirmed you're allowed to video anyone in a public street, and they can't really do anything about that either. Unless it's a child, there would be restrictions around that. But someone can go into a public street and film. So they were saying there, unless the protesters really step over and lay a hand or have continued abuse on an individual, they're very restricted. But the safe buffer zone would now produce legislation that would protect our staff and our patients, and it would mean then that they were breaking a legislative a law, and that the PSNI could intervene.
Thank you.
Okay, thank you, Jerry. And I'm going next to Colin McGrath, and then I have Arlea. So I'll go back to you, Colin. Go ahead, please.
Thank you, Chair. Sorry, I don't really have a question because what I was looking to ask has been answered, but I wanted to show my support for what we're hearing today. I think sometimes people could say that there's a thin line between protesting and harassment and intimidation. There isn't a thin line here. It's blindingly obvious what is happening is intimidation, and I think that we really do need to have these evidence sessions to help inform the legislation that we need to put in place here. But just wanted to put my support to the staff that are here today and what they have said. Thank you.
Thank you, Colin. And Arlea. Go right ahead.
Yep, thank you, Chair. I think it's taken us all a wee while to unmute this morning for some reason. There seems to be a bit of a delay. So just first and foremost, thanks very much to Dr. Kirk and to the rest of the panel for the evidence that you've gave here this morning. I think that just through what we've heard, and I know all of the members clearly seem to be in agreement, the experience that's being suffered here by women and girls, and indeed by your staff, is just despicable. It's difficult to even listen to, never mind to experience yourself. So thank you for sharing that with us. And I just wanted to ask the question around, in terms of supporting the bill. It was contained, I think, within the correspondence of the Belfast Trust, just around the regular engagement that you have had, thankfully, with the PSNI in trying to agree some of those strategies that can try and reduce and mitigate the stress and harm that the staff and the patients have been enduring. But I suppose a simple question is then, with all those strategies in place, and it's good to hear about, it shouldn't have to have even got that stage, but, with the blacked out windows, with the security guards, and it was also mentioned around some CCTV. And I'm just wondering, with all that in place, clearly those mitigations and those strategies still aren't working. It's still not, what my concern is that it's still not resolving the situation where people are having to endure, that aggression and that abuse from people who are, from so-called protesters. And I just think the example that Dr. Kirk gave earlier around those two cases, where those women in their personal circumstances in relation to their physical health, the fact that those two women, if they hadn't have presented into the clinic to get that medical care, that, they basically could have lost their lives. They could have died as a result of that. So I think that, I think that alone has been the most powerful testimony that we've received today, and that's the reality of what we're dealing with. It's not about protests. This is about threat to life. You know, both of those women clearly could have lost their lives, and I think that's really, really worrying. So it's just to say, obviously, I'm sure that you are in agreement, but with all the good work that you have tried to do up until now in mitigating what you are going through, is it your opinion that with the CCTV, with the windows blackened out and with the security guards, that it's still not enough, and that this bill will hopefully do more to try and do away with this behaviour and let you work in peace?
Well, if I could just come in there on behalf of the Northern Trust, really, absolutely, we all agree that buffer zones should be put in place. We've tried to mitigate. We've tried with every set of circumstances. We have tried to, put in some sort of rationale and protection against towards our service users. But really, in reality, we are in a hospital site because we have no other option to try and ensure that our service users are kept safe. I do believe that we should be within the community. We're in a hospital setting to ensure that as minimum disruption to our service users and distress as we can at the moment. But in terms just of live streaming, the emotional and the mental abuse that our service users have to live with going forward. So, it could take 30 minutes to calm somebody down when they come into the clinic before the clinicians would even start their consultation. On top of that, the belief and the fear that somewhere along the line that recorded information that could be posted on social media has long-term mental health repercussions. Women do not attend our services lightly. It's a huge decision for any woman to make. And on top of that, then to live with that ongoing psychological fear of what's going to happen to that filament that they have absolutely no control over really does urgently need to be addressed.
Yeah, thank you. Orlia, anything further from yourself?
No, Chair, just thanks very much again to the panel.
Okay, thank you. And I would like to also reiterate that thanks to the panel and indeed the remarks made by Colin in relation to the difficult scenario in which you're working. And I think even though members will have had a broad understanding from previous briefings around the difficulties here, I think this is of a different quantum in terms of the impact that this is having on women and girls seeking a range of healthcare, and also on staff to whom we all have a duty in terms of, and I think that has been glossed over in a sense because we've been focusing on the people accessing the services, but the very same things are being experienced by staff members as well. And I think that's crucial, that's important, that's understood. So I want to thank you all for the work that you do every day and for the stress and difficulties in the sector, but also particularly for coming to the committee this morning and to addressing it. I would just like, before we go to pick up, maybe I think Kieran is looking to make some remarks and just some brief remarks before we close, but I'll check with Kieran. Go ahead there, Kieran, please, just check if I can hear you.
Thanks, Chair. You can hear me okay?
Yeah.
Yeah, it's just a comment from the Southeastern Trust perspective, and apologies I was late with technical difficulties trying to get in. To date, since we started our service back in June 2020, we haven't had any protests outside our facilities. We do run our facilities from a hospital site within the Trust, and at this point we haven't, as I said, had any protests or any concerns from staff. But obviously I do want to emphasise as well what's been articulated. I mean, the staff do obviously have those fears in the background that they could at any point come across or encounter that, and obviously we want to support our staff in line with that. So and I also want to obviously say, what's already been discussed through the different colleagues and trusts, obviously the Southeastern Trust would support all of that just at this point.
Yeah, thank you. And I'll just check if there's any of the other panel members who haven't had an opportunity to speak who want to make any brief remarks, or particularly if there's any of the trusts that haven't been heard from, if anyone wants to make any further remarks. I'll just check with the clerk and with yourselves. Is there anybody else wishes to come in at this point?
Colin, this is Hilary Campbell from the Western Health and Social Care Trust, just to comment ahead of service for, and just to say that, in relation to your talking there about staff and the importance of staff, we do have a valued member of staff off sick and a service that has not been delivered at the moment because of that, based in the community with strong plans to move it into a hospital environment because of this. So presently we don't have a service, but we still have the protesters who come and still stand outside that particular health centre. each week. So irrespective of the fact that it's not a service that's been offered there, staff are still aware that this is happening. Now, we have our electronic mechanisms to report it, and we work very closely with the PSNI as well. But yes, it does have and continues to have a huge impact on staff, even where services are not delivered.
Thank you, Hilary, for that perspective. And anyone else on the panel want to say anything or add or contribute anything at this point? No, I don't see anything further there. So I will listen. I will just wrap up. I want to wish you and all of your staff, and please extend our solidarity to staff who are feeling under that level of pressure in the delivery of healthcare services in this day and age. I just think that's absolutely ridiculous. But anyway, I want to thank you all and for coming to our committee session and for contributing to our scrutiny of this bill. Thank you.
Thank you.
Okay, thank you. Okay, members. So I think there was an indication there from Paula around this, what had been referred to as a clinic masquerading as an abortion clinic, and Paula has suggested there that members that we write to the department in relation to that. I think also, members, we should reflect our concern at what we have heard today in relation to the current situation, and I don't think it's acceptable that people should be dealing with that level of trauma in accessing care. But I think we should flag that to the department and ask them to do everything in conjunction with other departments or agencies, including justice and policing. Ask them to do everything they can at this minute in time, short of any legislation that may come through, to mitigate what we are hearing about here this morning. I just think it's beyond the pale, to be quite honest. Would members be agreed that we include that in the letter that Paula has suggested, and that we write in relation to that clinic and ask what's being done in relation to that?
Yeah, Chair, members. Sorry. And I completely agree with Paula's proposal. I just also think at the end there from the Western Trust here, and that I'm not sure if Hilary says that the doctor that's off sick, that service isn't being commissioned in the Western Health and Social Care Trust at present. I'm not sure if that's due to the protests at the clinic or what it's due to, but it might be just something else to flag up if that's a trust area that's still not providing the service.
Yeah, so members content with that? Yeah. Okay. Okay, members, I think that is that probably brings us to a conclusion on that session for now, but it certainly does provide significant context for our next number of evidence sessions in relation to this bill and the situation that is extant out there at the present time. Okay, members, so moving on then. I have been advised that the official who is briefing us on the health protection coronavirus amendments around the COVID status certification is not available until 1 o'clock. So I will propose, if members are content, that we'll defer that to 1 o'clock, and I'll go then on to the further agenda items around the other SRs that are in front of us this morning. Are members content with that? Yeah, thank you. So I'll pick up then so the next four agenda items then would be statutory rules relating to coronavirus travel restrictions. An official from the department is here today to brief the committee on the provisions of the SRs. I refer members to the clerk's memo at tab 8.1 of your pack and to copies of the SRs at tabs 8 to 11. Can I now welcome by Starleaf Miss Carol Picton-Linus, who's Head of International Travel Regulations. Can you hear us there okay, Carol? So I'm not hearing you, Carol. Can you just check if you're on mute or still not hearing from you there, Carol, at this point in time? Carol, it might be yeah, so we're here.
Yeah. Yes. Sorry, apologies. Yes, I'm here. Thank you, Chair.
Yes, that sounds fairly clear there now. So thank you for that. So Carol, could you go ahead then and brief us on the SRs, and we'll go to members' questions then following that.
I will indeed. Thank you very much, Chair. So thank you for the invitation to attend today's meeting of the committee. Committee is considering 4 statutory rules which have been made to generally underpin executive decisions taken in relation to international travel. If I may make an overarching summary of the suite of regulations the committee wish to consider today, they are SR 2021 number 301, number 312, number 313 and number 316. This suite of regulations underpin the Executive's agreement to align with the UK Government and the other devolved administrations in relation to border measures in respect of international travel, and in particular the recent rapid response to the current Omicron variant of concern. If the committee is content, I will briefly summarise each of the regulations in the order in which they were made. So the first regulation that we're discussing is SR 2021 number 301. They are the Health Protection, Coronavirus, International Travel and Operator Liability and Information to Passengers Amendment Number 9 Regulations, Northern Ireland, and they came into operation on the 22nd of November 2021. These regulations made changes to the Health Protection, Coronavirus, International Travel Regulations 2021 and the Health Protection, Coronavirus, International Travel Operator Liability and Information to Passenger Regulations 2021. And primarily these regulations were made to provide specific definitions in the principal regulations for the EU Digital COVID Certificate, the European Microstate and the North American Certificate. They also clarify that a reference to a country does not include a reference to the overseas territories and dependencies of that country unless otherwise stated. Regulation 5 of these regulations amend the principal regulations to make a typographical correction. And these regulations also removes the provisions for a child under 18 having to self-isolate, as a statutory rule introduces a policy that all children under the age of 18 are deemed fully vaccinated for the purpose of international travel. They also clarify that enforcement of the requirement to isolate regarding a child only applies when that child has arrived into Northern Ireland from a red list country. They remove the requirement to provide the proof of residency for those vaccinated in the United States or those who have participated or are participating in a clinical trial regulated in the United States, and to accept vaccination certificates issued at state level in 3 US states. They are the New York Excelsior Pass Plus, from California the Digital COVID-19 Vaccine Record, and from Washington State the WA Verify. And this is to provide parity for those non-residents vaccinated in the US to be able to comply with the inbound policy and to provide parity for US and other countries and territories in scope of the vaccinated policy. As I mentioned earlier, they clarify that all children under 18 are deemed fully vaccinated for the purpose of international travel, regardless of their country of residence. They also define those countries and territories which are approved third countries and territories for the purposes of vaccine certification and the UK vaccine rollout overseas. And they clarify the statuses of overseas territories and dependencies of relevant countries. And this is where they use their respective mainland countries' certification solutions. They also insert 32 countries and overseas territories in the list of countries and territories that we now accept as part of the rollout of the fully vaccinated policy. I don't know, Chair, if you want me to cite those 32 countries?
No, I think we have the information there. I don't think we need to go through them.
Okay, thank you. They also amend Part 1 of Schedule 4, persons who are exempt, to the principal regulations to clarify that seamen and masters, maritime pilots, ship inspectors and aircrew do not need to complete a passenger locator form regardless of the country they have arrived from, and clarifies that road haulage workers are exempt from completing a passenger locator form, and simplifies the exemptions from the requirement to self-isolate applying to certain categories of transport and border workers. They also amend the Schedule 4 in relation to foreign diplomats and their dependents to clarify requirements in relation to self-isolation and managed isolation, so that foreign diplomats arriving from non-red list countries are now automatically exempt from self-isolation, in that there is no need for their mission to confirm the individual is undertaking essential work. Part 2 of Schedule 4 is further amended in relation to the condition that applies to the exemption from the requirement to provide information, i.e. the passenger locator form, in respect of transit passengers, to provide that they do not need to complete a passenger locator form so long as they remain airside and do not pass through immigration control. Regulation 2 of the operator liabilities is also amended to make a typographical correction. And then finally, the regulations make consequential amendments to the operator liability regulations, and that regulation 4A is the requirement on operators to check vaccination status. As a result of the amendments mentioned earlier relating to providing proof of residency for those vaccinated in the US or who have participated or are participating in a clinical trial regulated in the United States. If I move on to then SR 312, these are the Health Protection Coronavirus International Travel 2021 Consolidation Amendment Number 9 regulations. Northern Ireland 2021, they came into operation on the 26th November, and these regulations made changes to the Health Protection Coronavirus International Travel Regulations 2021. And these regulations were made to add 10 countries to the red list. They were Botswana, Eswatini, Lesotho, Malawi, Mozambique, Namibia, South Africa, and Zimbabwe, and they were added to the red list. They also amended Schedule 7. That deals with managed isolation from red list countries in respect of those people arriving from or transiting through a red list country between 4 p.m. on Friday the 26th of November and 4 a.m. on Sunday the 28th of November to self-isolate in their homes or other suitable places as though they were in accommodation designated by the department. And that period I've mentioned there was the interim period between the making of the regulations and the standing up of the managed quarantine services. They also amend Schedule 8 of those regulations, and this is prohibition on arrival of aircraft and vessels to prevent aircraft and ships from the red list countries mentioned above arriving in Northern Ireland except in limited circumstances. And those limited circumstances is the operator must not cause or permit a relevant aircraft to land in Northern Ireland unless landing in Northern Ireland is reasonably necessary to secure the safety of the aircraft or the health and safety of any person aboard it, or the landing is only for the purposes of refueling or aircraft maintenance and no passengers are permitted to board or disembark from the aircraft, or the aircraft is an air ambulance and landing for the purpose of transporting a person for medical treatment. The third set of regulations then are SR 2021 number 313, excuse me, and these regulations made changes to the Health Protection Coronavirus International Travel Regulations 2021. And these are a small set of regulations which added 2 additional countries to the red list, and they were Angola and Zambia. And similarly, they amended Schedule 8, prohibition on arrival of aircraft and vessels, to add Angola and Zambia to prevent aircraft from these countries arriving in Northern Ireland except in limited circumstances. And then the final set of regulations, Chair, is SR 2021 number 316, the Health Protection Coronavirus International Travel Operator Liability and Information to Passengers Amendment number 10 regulations, and they came into operation on the 30th of November. And these regulations were primarily made to slow the ingress of the Omicron cases and was deemed to be a proportionate response at that point in time. So these regulations made changes to the Health Protection Coronavirus International Travel Regulations and the Health Protection Coronavirus International Travel Operator Liability and Information to Passengers Regulations, Northern Ireland 2021. So these regulations, as I mentioned, were made in response to the Omicron variant of concern, and they amend the testing regime for eligible non-red list arrivals, i.e. those arrivals to Northern Ireland who are fully vaccinated upon arrival, to the effect that there is no longer the option to take a day 2 lateral flow device test followed by a confirmatory PCR test. So those provisions that we put in previous regulations are now undone, and that all day 2 tests must all be PCR tests. And they also amend the self-isolation regime for eligible non-red list arrivals, i.e. those fully vaccinated, to the effect that they now must enter into self-isolation upon arrival, and they must remain in self-isolation for 10 days or earlier if the day 2 PCR test yields a negative result. And then finally, the operator liability regulations are amended to update the information that must be given to passengers travelling to Northern Ireland. So, Chair, I trust that's been helpful to members. I'm happy to take any questions that members may have.
Okay, thank you, Carol. And I suppose I don't have a question as such. I suppose I just do want to state that I think it's appropriate and welcome that travel is looked at very quickly in the case of variants. And I recognise that there is a bit of uncertainty around Omicron, and certainly everyone's hoping it will be less impactful, but worried about the transmissibility and indeed the lack of clarity. So, but you don't get a second opportunity to move quickly in a sense. So I think that's something that certainly would be. And I think it's a welcome step that we're going back to the more what appears to be more robust PCR testing. But so listen, I have a couple of indications there from members. I'll go to those, and we'll work our way through those questions. I'm going firstly to Colin McGrath, and then I have Pam Cameron. So Colin, go ahead, please.
Thank you very much indeed, Chair, and thank you for that information. Just a couple of questions. I sort of asked this question of the Minister whenever he was in, and it's just maybe to underpin it with yourself. The PCR day 2 test, to be taken before, or can be taken before day 2? So in other words, you could take it on day 1, or potentially, if it was available, if you arrived into an airport, you could go straight into a testing centre, have your test, and if you got an express, like 3 hours later, response that said negative, you would be free to release yourself at that stage, isn't it? It's anywhere up to 2 days.
Yeah, it's on or before day 2 testing, yeah.
Okay. And what about people that will have had potentially COVID in the last, say, 90 days? If they were to travel away, they're going to come back and take a PCR, which might show that they have a positive result because they still maybe got some of the virus in their system. But how do they then navigate that difference between making that proof? And maybe just a little stage before, whilst it's not been covered today, what would happen now that they're required under subsequent regulations to take a test before they come back? If again they take a test, say wherever they are, and it shows up positive because they still have it in their system.
Okay, so if I can address your last question first, and I know it's possibly not for the scope of this, but as you've mentioned, there was regulations that came into force on Tuesday morning in relation to standing up the pre-departure testing. So pre-departure testing can be by way of a PCR test and an LFD test. So the LFD test is slightly less sensitive. So in the sense of those who have had the illness or that has had COVID, it mightn't pick up a positive result on that respect. And in respect to your first question, we're conscious of this issue, and consider it. UK government in particular are looking at this issue, and they're looking to bring it further for discussion. Obviously, as more people have become infected, then obviously this will become an issue. But for the moment, for the vast majority of travellers, we're still insisting on PCR testing for post-arrival testing.
Just maybe to tease that out a little bit, because I could understand if somebody had COVID 2 weeks ago and was going away for Christmas and then was actually getting a test before coming back and it came up positive because it's still in their system, that would then disbar them from travel, wouldn't it? So they would actually then be trapped wherever they are. Is there no system that proof can be used in the passenger locator form that actually says, well, even though you've got the test that may be positive, you can also see from the system that I've had COVID 3 weeks ago and therefore unlikely to have it again? Or is that just...
Yeah, current policy is at the moment is that we don't have provision for the COVID recovery certificate, and even if we did, the COVID recovery certificate would only be in terms of people who'd recovered 30 days earlier, 30 days to 180. So in the situation you're describing there, 2 weeks, it wouldn't apply. But no, there's no mechanism for putting anything on the passenger locator form. That's really purely for contact tracing services. It's separate from the testing regime.
So what happens to a person in that situation?
Well, unfortunately, if they test positive for COVID, then they have to abide by the restrictions and the regulations that are in place at that time.
Okay, I can see that causing quite a problem for people. Is there no way that can be... if you're saying that it's something that we just don't have, is there a way of having it?
Well, again, that would be a policy decision, and that would be something that the executive would need to make a decision on as well if we went down that route. But obviously, as I mentioned before, all these issues are now coming to the fore as a result of all the measures that have been brought in, and they will be discussed in due course.
And do other places have the capacity for those certificates, etc.?
Some countries do have COVID recovery certificates, yes, and I think yes they do. But I think it's in relation to if you have recovered 30 days ago.
And is that any of the UK countries or?
No. UK government and devolved administrations not at this point in time.
Okay.
But that's not to say it's not on the table at some point, but it's just not been. It's not a current policy.
Okay. And then in terms of people that are travelling in, if they are travelling to Northern Ireland, say coming home for Christmas, they're required to provide evidence of vaccination. Is there any cross connectivity between the app that people use to go gain entry to hospitality sector? Because they've had to prove their vaccination to get in to here, but then they maybe don't have the ability to draw down the certificate for the hospitality sector because they weren't vaccinated here, but obviously they've had to prove that they were vaccinated to get here. So I'm just wondering, is there any cross connection between your work?
Well, I think this is possibly a question for the next official who's coming on in terms of the local restrictions. But my understanding is that proof of vaccination certification and the definition of fully vaccinated, I think is reflected in local restrictions, regulations. So I don't want to make a definitive comment on this, but I'm assuming that that proof of vaccination would be acceptable for entry into establishments here, but I'm not sure how that mechanism would work. So apologies for that.
Okay. Carol, thank you very much indeed. Thank you, Chair.
Thank you.
Thank you, Colin. And Pam, go ahead, please.
Thanks, Chair. It's just taking a wee minute on system to unmute me there. I suppose, first of all, to say, I think, Chair, Colin's making some very valid points there around that COVID recovery certificate. And even if we don't have that anywhere else in the UK, I think it is maybe an issue that the committee should write to the Executive Office on and actually clarify whether we are actually looking at that scenario, because I think that's pretty important. Carol, thank you very much for your attendance at committee today. There's obviously some concern around the affordability of the pre-departure and the day 2 and 8 PCR tests in light of the removal of the lateral flow testing as an option. Could you tell us what discussions have taken place between the department and test manufacturers in relation to the affordability of PCR tests?
Well, in terms of the PCR testing as such, we have, the non-vaccinated arrivals are still in the same situation. Nothing's changed in relation to them. So in terms the regulations in terms of the requirement to undertake day 2 and day 8 testing still remains the same. The actual provision of these tests is not devolved to Northern Ireland. It's a reserved matter because these are medical devices as such. So any discussions between the providers of the PCR testing would be a matter of discussions between the Secretary of State for Health and Social Care and not this department. So we are aligning in terms of using the private providers to provide PCR tests, and then as was the LFD tests. So in terms of affordability and the cost to the public is a matter for HM Treasury and the Secretary of State for Department of Health and Social Care, I'm afraid, Pam. Okay,
thank you for that, Carol. Okay. And could I ask you what assessment has been conducted into the likely impact of fresh restrictions? And I presume you're going to tell me something similar for this one.
Yeah, probably.
Travel, footfall, and the potential impact this will have, obviously, on that travel sector. So have there been any discussions aimed at securing additional funding for the travel sector in light of this?
Okay, well, 2 things, if I can just point out that these restrictions are temporary measures. So, the idea is that we would review these within 3 weeks of whenever we implemented the restrictions. So we're coming up very much next week, a week after, to the 3-week review, where, consideration will be taken as to whether we can lessen these restrictions or maintain them. In terms of, again, as I said before, in terms of talking to the travel industry, that would be an issue for the Department for Transport, Secretary of State and HM Treasury. And in terms of financial assistance to the travel industry, again, that would be outside my remit, I'm afraid.
Thanks, Carol.
Sorry, I can't be more helpful, Pam.
Thank you. And just in general terms, and I note you've mentioned the review element of this, Carol, but in relation to the unfolding learning around Omicron, is there any further regs being considered at this point in time in relation to travel?
Well, the last set of regs we did, Chair, as you probably know, came into operation on Tuesday, the 7th of December. There are no plans to do more additional regulations at this moment in time in terms of further restrictions or lesson until that review is undertaken in the next week or 2. So I couldn't possibly commit to that.
Yeah.
Sorry.
Okay. Listen, that's okay. I don't see any other indications, so I think we can thank you for attending, giving us your remarks, and addressing members' questions, Carol, and we can then move on to our formal consideration.
Thank you. Thank you so much. Thank you. Bye bye.
Okay. Bye. Okay, members, thank you. We now move on to our formal consideration of these particular set of regulations. All of these SRs are subject to the negative resolution procedure, and the Examiner of Statutory Rules has said that these rules are in breach of the 21-day rule, but is content that the Department has provided a satisfactory reason for the breaches. So going firstly to SR 2021 2021/301. Have members any further issues to wish to raise in connection with this statutory rule? No, thank you, members. So therefore, can I ask members to agree formally that the Committee for Health has considered SR 2021/301, the health protection, coronavirus, international travel, operator liability and information to passengers, Amendment number 9, Regulations NI 2021, and has no objection to the rule. Are we agreed? Agreed. Thank you, members. SR 2021/312. Have members any further issues they wish to raise in connection with the statutory rule? No. Thank you. Then, members, I would ask you to agree formally that the Committee for Health has considered SR 2021/312, the health protection, coronavirus, international travel, 2021 consolidation, Amendment number 9, Regulations 2021, and has no objection to the rule. Are we agreed? Great, thank you, members. And item 10, SR 2021/313. Do members have any further issues to wish to raise in connection with this statutory rule? No, thank you, members. I would then ask members to agree formally that the Committee for Health has considered SR 2021/313, the health protection, coronavirus, international travel, 2021 consolidation, Amendment number 10, Regulations 2021, and has no objection to the rule. Are we agreed? Yep, thank you, members. And finally, in relation to this element of it, SR 2021/316. Have members any further issues to wish to raise in connection with this statutory rule?
Yeah, Chair, could we, just following on, if it hasn't been formalised after what Pam had said, could we write to the department and just ask them that, about that scenario? Because given that we have thousands, literally, of people, thousands and thousands, if not tens of thousands every week, or up to 10,000 every week that are being positive, then how do they progress with that day 2 test or that requirement for day 2 when they return? If that then is positive because they still have some of this in their system, then they would be required to isolate for 10 days, where it's actually, they maybe only had the coronavirus maybe 3 or 4 weeks previously or 6 weeks previously. Maybe just to raise that with the department and ask them, are they any further at adding those certificates to the app?
Yeah, and in relation to that, Colin, are you content that we consider the rule formally but rate in parallel? Or
yeah, absolutely. I think the testing is critical because it obviously picks up people that have it the first time and then they aren't coming back and spreading it. But it's about those people that have maybe in the 1 or 2, 3 months previous that have had COVID that still have it in their system. So it shows up in the test positive, but they actually don't have the virus again. Then they are required to isolate for 10 days for no reason. So that's the purpose of those certificates that are used in other countries. So it's just to get an update to see if we're going to use them here.
Okay. So yes, it's more arising as a result of the rule rather than, yeah. Okay. Yeah. Are members content that we write along those lines? Yeah.
Chair.
Someone looking in there? Yeah. Pam, go ahead.
Yeah. Thanks, Chair. Yes, just to agree with Colin there completely. And I think we should write to both Department of Health and to the Executive Office rather than write to Health to maybe get a response to say, no, you need to send us to the Executive Office. I think we should write to both.
Yeah. Okay, thank you. And are you also content that we do that in parallel with the consideration of the rule?
Yes, Chair.
Yeah. Okay, so members content with that proposal we write to both in relation to that? Yeah, thank you, members. And okay, thank you. Well, then I will move on to ask members to agree formally that the Committee for Health has considered SR 2021/316, the health protection, coronavirus, international travel, operator liability and information to passengers, Amendment number 10, Regulations NI 2021, and has no objection to the rule. Are we agreed? Yep, thank you, members. Okay, members, we're going to move now into a closed session for our Autism Amendment Bill deliberations. I think maybe we could be doing a very short break again. So could I ask that members return and we'll resume again at 12:30 and we'll be resuming in closed session for the Autism Amendment Bill deliberations. Thank you, members. Okay, thank you, members. So we're resuming now with item 7 on the SR 2021/315, and this is around the COVID status certification. There's a small amendment to align the definition of rave to that of a house party, and it also deals with the issue of gaining entry to relevant settings with a higher risk of transmission of COVID-19. We remember that we were briefed on the provisions last week, and the department we raised a number of issues. The department have responded, and that's included in table papers. So that is in table papers as tab 7.4. The examiner of statutory rules has reported that she has no issues to raise with the rule, and a debate on the rule is scheduled for the plenary on Monday. So we do have Elaine online, do we, Clerk?
We do, Chair. She's available for any questions members may have.
Okay, I have a brief one, just if you can bring her online there. I have a brief one that I want to raise with her, please. And then I'll take members in at that point. So Elaine, can you hear me okay?
Yes, I'm here, thanks.
Yeah, you're a little bit faint, Elaine, but I'm hearing you clearly, but it's just the volumes, maybe if you can put up your volume a little. I was looking to ask that around the definition of a rave, and I suppose I'm really wondering why that has been included, why that's seen as significant. It's not something I'm aware of raves in houses being a major issue. So what's the rationale for including it, and what's the definition of a rave for the purposes of enforcement?
Yeah, you're right, Chair. It's not a massive issue. It was really a tidying up exercise. The executive had agreed that gatherings of up to 30 were permitted at private dwellings, and that included the 30th person. But the way the definition of raves was that as soon as the 30th person walked through the door, the music had to be turned down. So it was really just a tidying up exercise with very limited practical effect, and just made sure that it was clearer for enforcement what was permitted in private dwellings and what wasn't.
Okay, and just briefly in relation to that issue around enforcement, Elaine, can you give us any further indication in enforcement? And I want to just, I suppose, in my remarks, widen that out to significant concerns raised with me over the past week or two around lack of enforcement on a whole range of issues, mask wearing and different things. And I'm not asking you to answer those questions, but in relation to the enforcement of this, are you satisfied that it is practical and that the steps are in place to ensure that it is that we do see a meaningful implementation of the rules, so that we get the benefit that may accrue?
Yes, we've been engaging very heavily in the last 2 weeks with PSNI and even just with sectors. We've had multiple sector meetings last week and this week, and there's another one tomorrow. So we have been talking to all of the sectors, making sure that they have guidance, answering their queries, working with PSNI to ensure that they are able to enforce as we need them to. So yes, I am confident that measures are in place to address that.
Okay, I have indications then from Colin, Pam and Deborah. So we'll go to Colin first.
There we go, Chair. Thank you very much. Chair, all this talk of raves really does bring me back to the 90s, and I'll just put my glow sticks away in the drawer and have to go for a little while longer. But really, I suppose the question just that I wanted to check with Elaine was, I know that this statutory regulation, although people sort of see it as hospitality sector, it also extends, am I correct, to cinemas and other types of events, and it's just that in those settings there may be more likelihood that children and young people may be attending. So it's just maybe to get an idea about the age range of the regulations for those sort of non-hospitality settings that are included in it. And then in terms of overseas, quite a number of people that are coming home for Christmas are asking about what will they do to be able to get access to various places under the regulations that are there. And then there was also an issue about people that aren't vaccinated. How do they get access to be able to get proof to be able to allow them to gain entry to various places as well? So thank you, Chair.
Okay, in terms of the age range, there's no venues that this applies to anyone under 18. So these only apply to 18 and over for every scenario that we have these required in. Overseas visitors, if overseas visitors have an international certificate which aligns to the European QR code system, then our verifier will recognise it. However, I should also say that the regulations don't require a QR code that can be recognised by the verifier app, and that's intentional at this moment because of the other issues that people, or the other evidence people will bring with them. So all that is required from a person, whether they're from here or from elsewhere, is certification in paper or electronic form that they have completed a course of doses of an authorised vaccine, with the final dose having been received at least 14 days before that. Now, if they're able to prove that using official documentation from their country, then that is, under the regulations, acceptable. The other thing just to mention, and it covers the non-vaccinated people as well, if they aren't able to provide evidence of that in a way that people will recognise, they always have the option to take an LFD test instead, and that applies to the non-vaccinated, so that they're not disadvantaged and not able to access venues under the same conditions.
Yeah, okay. And just by way of a follow-up, that Elaine, could you take away the issue about communicating that fact? I'm still getting, I'm sure everybody is getting emails from people saying this is forcing people to take a vaccine. It's not. And I think it's crucial that that information is got out there, because people maybe can avoid winding themselves up, if not others, around the issue about what this entails, and the fact that it's a COVID status. We're trying to establish that you don't actively have COVID before you go into a very high risk setting. But I think there's a huge need to nail that and to kind of emphasise that out there in the public.
Yes, you're right. There is a misconception still out there amongst a large number of people that this has to be vaccine only, and we're doing as much as we can on that front. And certainly, this is not about driving people to get vaccines if they don't wish to do that. This is about ensuring safety in those venues, and we will continue to look at the comms over the next few days.
Thank you, Pam.
Thanks, Chair. And thank you, Elaine, once again. I suppose just on the back of the last comments around, I would agree and welcome that clarity that you don't require to be vaccinated to receive one of these. Although I have to put on record as well that our party, the DUP, remain opposed to the COVID certification policy based on the lack of evidence and the lack of success we've seen elsewhere. But my question's more in relation to PSNI, Elaine, and obviously they've already signalled that they have competing pressures because they do face normal calls for service, which are very great. And obviously the idea that they can allocate infinite resources to enforcing COVID passports is really, in my opinion, unrealistic. Do the Chief Constable's representations to the Minister not highlight that the scheme is simply not enforceable to the extent that it will produce tangible effect on public behaviour?
So yes, the Chief Constable raised some issues, and we have been working with PSNI to try to address as many of those as we can before the requirements come in. So yes, there's always going to be a judgment for PSNI in terms of the resource prioritisation, as there is for any organisation, I suppose, at the moment. I guess the other thing to add is that environmental health officers are also able to enforce these regulations. It doesn't only fall to PSNI, and they will work together, those two organisations and two bodies responsible for this. So there is that other method of enforcement as well.
And I appreciate that, Elaine, although I would point out, as has been pointed out many, many times, especially in the media, that there has been little to no enforcement of any of these measures throughout. So I just want to make that point.
Okay, thanks.
Thank you. Deborah, and then Jerry, and then Paula. So Deborah.
Thank you, Chair. Sorry, it's just it is taking a wee bit of time today to unmute. No, I would share the concerns there of my colleague Pam Cameron. You know, I've asked for the specific evidence, and I'm not seeing the evidence that we may have got from the likes of Scotland or Wales, where things like this have been implemented, in how effective it is. And I hope that does come before we have the debate next week, because it may actually help in terms of some of the understanding around some of this as well. Now, I know last week we discussed about, with the CMO, he said, it's minimal, but we're adding it to the range of things that we have, and this is causing distress to an awful lot of people, and people who are doubly jabbed. And I've been inundated with people trying to access their passports who are finding it quite difficult. I have to say, now last week we discussed about staffing levels for the helpline. I'm just wondering if we have any updated figures in terms of how that will be manned over Christmas. And the other thing is as well, we talked about the vaccination cards, and that was still, you were still able to show that as an interim period. Do we have any timescale yet of when that is going to stop and when people have to switch to having their barcodes? Sorry, QR codes.
Okay, so the evidence of the effectiveness, I guess there's two sort of difficulties that we always face in terms of getting evidence of a specific measure for COVID, and that is that it's very difficult to tie down exactly where someone contracts COVID. And so we have to use the evidence of these are the most at-risk settings in terms of surfaces, air, ventilation, those types of things, and make a judgment call, and fairly scientifically based judgment call as to the measures that are then put in place to minimise transmission. We have the paper on our website that the Chief Scientific Advisor developed on this, and even with other jurisdictions, very few have had it in long enough to be able to say, you'll never know what would have happened if you didn't have it, and that's the other challenge. So I suppose there's probably not much more that's going to come forward between now and the debate, if I'm honest, and I don't know that we will ever be able to say one measure in particular has had a specific impact. And it was the same when we had different measures of social distancing and face coverings and limits of table of 6 and closures of certain sectors and not others. We can never point to say that one measure has this impact on the transmission. It's just not possible to do it. We can use the evidence that we have to make as a scientifically based estimate as we can as to what most likely is going to reduce transmission, and that's really what we do. On terms of the staff line for the passport, I'm not involved in the technology side of things, thankfully, so I don't have the figures on the staff to hand. But what I would say is that to people who are getting worked up and panicking on this, please don't, because there's really there's no need. You've still got your vaccination card, your paper accept, that's going to be accepted. We mentioned the interim period, and there is no timescale for us to change over. We haven't got a fixed time in mind where we want to say those paper cards aren't accepted. What is important is that people are able to access venues. If it turns out that it's not, that it's going to be disadvantageous for a certain group of people to turn on the QR code only option, then we won't do that. We will always allow vaccine cards. So our priority is making sure that people aren't disadvantaged. And we've got lots of scenarios and situations where people haven't been able to get paper QR code certification, and we will just keep that under review. We don't have a fixed timescale in mind where we're going to move to QR code only. It was the hope and the ambition, but it's not going to be done if it puts people at a disadvantage.
Okay, thank you.
Okay, thanks, Deborah. Jerry?
Thanks, Chair. Thanks, Elaine. I was trying to go over Hansard, but obviously it hasn't been completed yet for last week, so apologies if there's a bit of repetition, but I just want to make sure we have all the information. So just in terms of, do people still have to use photo ID even when they're using the COVID Cert app?
No, because the photo's on it. The regulations will be amended to make that clear. Okay,
and clarify as well, Elaine, people can't bring a physical lateral flow test to a venue. That's not permitted.
No, if you want to, you can take it on site, but you can't bring one that you've already taken with you.
Okay, and then what happens, I suppose, if people somebody takes a lateral flow test and they normally are required to upload it to the app, to the phone, but there's no access to a smartphone, what would happen in that situation?
if you take it on site, we don't require it to be uploaded. That there's obviously someone there who's able to see that you've taken the test yourself, and you can show the result then to them. There's no actual requirement to upload an LFD test other than to get notification as evidence that you took it. So in that sense, it's fine. They don't need to have access to something that they can upload there and then.
But if somebody takes it at home and they can't upload it to the app, is there provision to access venues?
Yes.
Or
There's a phone number that they can phone, and it actually also covers people who aren't from Northern Ireland. And so if they're from Ireland or from somewhere else and they're coming into Northern Ireland within that window, and they take a lateral flow, they can't upload it if they're not in Northern Ireland or resident in the UK. So there is a phone number that they can phone once they're here and get that uploaded and get the notification that they need. And it's published on our website, and it will be in the FAQs and guidance that go out as well.
Okay, just two final questions. Is there a requirement on venues to provide lateral flow testing and devices? And the final question is around the Human Rights Commission. I think last week we heard we were waiting on a report back. I don't know. I don't think that's came through, and certainly in the pack for today. And just a clarification, again, I tried to check Hansard just before, obviously, today's committee, but why wasn't the policy fully equality screened? Thank you.
Okay, so there's no requirement on businesses to provide LFD tests on site. It's an option for entry. What the LFD tests have to be given out to customers in boxes. So if anyone wants to take that option and they're not sure if the business provides them on site, they can take the test with them. So they can apply for them to be delivered to their house for free online, or they can pick them up at one of the pharmacies or other venues and take the test along with them to the venue if they're not sure if the venue's providing them. So that is an option. In terms of human rights impact assessment, we haven't received any comments as such from the Commission. We have invited those, and we will welcome them at any time that they are able to come through. We have published, or if it's not online, it'll be online today, the human rights impact assessment as it stands, and we will review that, and we have committed to reviewing that if comments come through from the Commission that would suggest we should.
Okay, thanks.
Okay, thank you, Jerry. Paula?
Thank you, Elaine, and apologies if this question came up last week. I'm a bit brain dead today, and it's in relation to people who got their vaccines both in England. They've moved back to Northern Ireland. They haven't been registered with their GP yet, and they're struggling to get their vaccine passports. What do they do in this situation if they can't get registered with the GP and get verification of the vaccines?
Okay, if they've received both vaccines in another area of the UK, it should be okay, because they'll be able to use the pass that they would have been eligible for in that region. The challenge comes if they've received one vaccine in one region and the second in another. So my understanding is that the region that they got their first dose in can give them a single vaccine evidence that is accepted, and then they can then exchange that almost for a COVID pass. But they will have to phone the helpline and do that sort of manually. There's no electronic way to do that on the app itself.
Okay, I picked up that about the phone line, so I'll go back to constituent with that, but that was my only query. Thank you, Chair.
Elaine, could that be included in the frequently asked questions section, because that does come up a lot, that issue?
Yes, we will. We only really resolved it in the last day or two, but we will get that uploaded by the end of the week and under the FAQs.
Okay, thank you. Alan?
Thank you, Chair. Would the officer agree with me that this particular piece of legislation is it's not really a standalone action, but to curtail the COVID infection rates, but rather just another part of a range of actions that have been implemented to protect public health?
Yes, I would agree. It is part of the wider measures of risk assessments, collecting visitor information, and all of those things that are already in place before we brought this in. Yeah.
Thank you.
Okay, thank you. I don't see any other indications from members there. So, Elaine, thank you very much. Definitely, whatever time travel opens up again, you will definitely be entitled to frequent flyer miles from somebody in terms of your appearances at the committee here. But thank you for now, and we'll move on to our formal consideration. Thank you.
Thank you, Chair. Goodbye.
Okay, so members, moving on then to our formal consideration of this SR 2021/301. Have members any further issues they wish to raise in connection with the statutory rule? Pam?
Yeah, thanks, Chair. It's really just to put on record that obviously we as a party don't support this rule, and it's not that I want to push it to a vote, given we only have 2 votes on the committee, but would certainly want to place on record our objection and our opposition to this particular regulation.
Okay, thank you, Pam, and that is on the record, and thank you. Jerry?
Yeah, thanks, Chair. I'm presuming it's going to a vote, so I'm kind of making my comments in that regard. I mean, we wouldn't and couldn't have went along with this if there wasn't the option to provide a negative test, although there's an option for that. I think there's still barriers in place for people, and we heard some of them last week and again today. But I said this before, and I think it's worth saying again. I think this system has been introduced after there's been social distancing has been removed legally in these venues. So you have to provide a negative test or certificate, but there's no requirement to socially distance in these venues. I think it's absolutely, frankly, absurd. And I'm concerned about people who may not have access to get the lateral flow tests, who may not have an address or who are vulnerable, and that. And I think there's, some questions, human rights organisations, I think we haven't heard the full report back from some of them. And I think obviously it's important and appreciate the need to encourage vaccination, something that I've done constantly, but the stated aim of this is not to actually increase vaccination, which is what Elaine said last week. So I just want to put on record my I think it's a non-vote, but an abstention. So not opposing or supporting the policy, but an abstention if it's a recorded position. Thanks.
Okay, and that's also on the record, and I think Pam has indicated there that she wants to very clearly place on the record, as do you, Jerry, your position around this, and that is on the record, and so we'll at this point in time, I don't think we require a vote necessarily. I'll put it to the members, and we'll take it from there. Alan.
Sure. Can I also, if we're all putting stuff on the record, can I also say that I'm disappointed that a collective decision taken by the executive is not, in this particular instance, being supported by the entire executive. I think that it does send out the wrong message to the public that there is a split within the executive on the way forward to curtail this COVID infection. And I think that all these things are only temporary. These are not meant to be for the rest of our lives. These are temporary until we get through this pandemic and until we see the effects of this new variant. So I just want to put on record my disappointment that that there isn't a collective view coming from the executive in this. Thank you, Mr. Chairman.
Okay, thank you. Any other issues to raise with this SR before I put it formally, members?
Chair.
Go ahead. Sorry. Go ahead, Paula. I'll take Paula first, and then I'll come back to yourself briefly, Pam. Paula.
Just to agree with Alan there, I very much concur with his comments. Thank you.
Okay, Pam, briefly, if you can, please.
Yeah, I'll be brief, Chair. It was just not really to respond to Alan's comments, but what I would say very clearly is that I would urge everyone who is entitled to take a vaccination, whether it's the first, second, third booster, to take that, because really that has been incredibly effective. We've seen a full year of vaccination, and we absolutely praise to the high heavens all those involved, from Patricia Donnelly down in that process. I think it's been incredible, the rollout, and we are seeing the really positive advantages of vaccination in terms of the hospitalisation rates that are now there. So I just wanted to put that on record and encourage people to do all those simple things that they can do to keep themselves safe and be sensible, especially throughout this Christmas period.
Yep, thank you. Absolutely. Thank you for that. And I do want to say actually that seeing as we were putting stuff on record, I got my booster yesterday, late yesterday afternoon, and I just want to thank my own GP for the absolutely fantastic operation they had. A very difficult evening weather-wise in terms of the volume of people coming through, but the care and compassion that they extended out to all of their patients was fantastic. So I was prepared for some after effects of it because I'm an adult and I knew that could happen, but I have to say it hasn't really been a problem at all, and it certainly was extremely efficiently done by the GP. So okay, members, I'm going to move on then to our formal consideration. Can I ask members to agree formally that the Committee for Health has considered SR 2021/301, the health protection coronavirus.
Sorry, Chair.
Yep.
It's 315. I'm just wondering if you're reading the wrong one.
Yeah, thank you, Clerk. Yes, I am indeed. So I will just go back to, yeah. So then, members, I will ask you formally that the Committee for Health has considered SR 2021/315, the Health Protection Coronavirus Restrictions Regulations NI 2021, Amendment Number 19 Regulations NI 2021, and has no objection to the rule. Are we content? Yeah, members content. Thank you. Okay, members, so listen, I'm going to make a couple of suggestions here, just given the time we're at. If I could suggest maybe the correspondence items are picked up via email with the clerk, if members can indicate if there's any issues they wish to raise, or if they're content with the correspondence memo. And also maybe suggest that we pick up on the forward work programme element of today's business on Tuesday if we can, because I know that members want to have more of a discussion, so I don't want to rush that today. So if we can move that forward to Tuesday if members are content. I want to check then, do members have any other business today that needs to be raised in today's meeting? Deborah?
Thank you, Chair. I am going to try and be very brief on this because I know time is tight, but we've recently heard from GPs in relation to the stress and the pressure that they're under. And indeed, we're all aware of the constituents that we have coming to us who have difficulty phoning in to a GP to get an appointment. I'm aware that GPs have to file how many patient contacts they have had within a week, and we've heard the statistics and how many they're seeing. So members of this committee as well have quite rightly raised the points in relation to the 1.7 million of improvement in telephone services and where that's being allocated. And we all know that GPs have been open during this time. And I think we need to see the figures produced on a regular basis, on a weekly basis, perhaps, to show, to support our GPs and the work that they're doing, and to feed some of that narrative which feeds into the low morale that GPs feel within their surgeries. So access to data will also help us demonstrate the strains upon the frontline staff and helps public understanding as well. I wrote to the Health Minister and have asked him whether he would consider publishing the weekly data of patient contacts in general practice in Northern Ireland. And I would just like to seek committee support also to repeat that call so that we can work together in securing solutions and get targeted support for our GPs, their surgeries, and ultimately, the patients that are trying to reach their GP surgeries as well.
Yeah, it's a significant issue, I think. Are members content with the proposal that Deborah's seeking to write there? Are you clear enough, Clerk? Yeah, I think that is, and I think it is important that we actually see that we follow through the issue of further support in the telephone systems and how that's landing on the ground and how it's improving or whatever. So I think that is an issue of significant concern. Okay, thank you, members. Any other business?
Chair.
So we have Jerry first and then Pam. Jerry was in there and ahead of you, Pam. Go ahead, Jerry.
Thanks, Sharon. Just an issue to kind of make yourself and the committee aware. I know there's still significant issues with the financial support scheme for dentists. I declare an interest of a relative who's a dentist, and she's impacted by this particular issue, and others are. But my understanding is that people who have taken maternity leave, there's complications around getting this financial assistance from the department or through the BSO. So maybe if we can, happy to be guided by the committee, but if we write to the dental officer or whoever to kind of ask what's being done to iron out these issues. I know it was an issue last year, but it still seems to be an issue for at least several people. So if we could write to the BDO, that would be my proposal.
Yeah, members content we write. I also think we should actually sometime in scheduling, and the Minister did reference that there's a new dental lead within the department, and I think there are significant dental issues, and I think it would be useful to go back to those. But are members content we write in the meantime, and then we take a look at how we can maybe schedule in a briefing at some point? Yep. Thank you. Pam? Yep. Thanks, Jerry. Pam?
Thanks, Chair. And I suppose it probably relates to the forward work programme more than anything. I should make a very brief comment to say, even the duration of this meeting today is evidence of the pressure that this committee is under. And I just think we need to be very cautious going forward. We have an awful lot of scrutiny still to do before the end of this mandate. And I think we have to ensure that bills such as the Adoption and Children Bill are completely and fully scrutinised to the best of our ability, and that we're not cutting short any process in that. So I'm just flagging up that the pressure that is on this committee, and I think we should be resisting pressure to take on further lumps of legislation which cannot be properly processed and scrutinised by this committee.
Well, that's why I wanted to have a broader discussion about that in forward work, and I was proposing rolling that forward rather than taking an AOB, Pam. So I'd prefer maybe we get a discussion in that. We haven't closed off our forward work programme discussion for this meeting. We'll be bringing that to Tuesdays. So if members are content, we'll discuss it more there in more detail there. Any other business, members, separate to that? No. Okay. Thank you, members, and I do very much appreciate your diligence and focus on some of those pieces of legislation and what has been, again, another very long meeting, as members have pointed out. Our next meeting, members, will be on Tuesday, 14th of December 2021 in room 30, and that's at 12:30, and that needs to be a sharp start, members. There is no lunch break on Tuesday, and there is a bills SFIA for one starting on at just after 1:30, so we'll need to start at 12:30 there in order to get through our business. So thank you for that, members, and please take care in the meantime. For Amelia Mahagov, Slán.